अच्छा अच्छा निकालिए। विश्वेंद्र 5 वाली थी है सबको क्लियर नहीं गया उसके पास की चाबू और उसकी
जिसमें भारत सरकार के विभिन्न मंत्रालयों विभागों के उच्च अधिकारी, पेंशन लिटिगेशन डील करने वाले नोडल अधिकारी, पेंशन डील करने वाले नोडल अधिकारी और वरिष्ठ पैनल लॉयर्स उपस्थित हैं। आप सबका हार्दिक स्वागत है। सुप्रीम कोर्ट तथा हाई कोर्ट के कई जाने माने अधिवक्ता भी आज हमारे बीच उपस्थित हैं। आप सभी गणमान्य अतिथियों का सादर स्वागत है, अभिनंदन है। साथ ही हम स्वागत करते हैं उपस्थित मीडिया बंधुओं का। पेंशन एवं पेंशनभोगी कल्याण विभाग केंद्र सरकार के सिविल कर्मचारियों की पेंशन एवं अन्य सेवानिवृत्ति हित लाभों से संबंधित पेंशन नीतियों, नियमों, निर्देशों को तैयार करने के लिए एक नोडल विभाग है। विभाग के अधिदेश में अन्य बातों के साथ साथ केंद्र सरकार के पेंशन भोगियों का कल्याण भी सम्मिलित है। इस संबंध में पेंशन भोगियों की शिकायतों का निवारण एक महत्वपूर्ण क्षेत्र है। माननीय प्रधानमंत्री जी के निर्देशों के अनुपालनार्थ शिकायतों के संवेदनशील, सुलभ और सार्थक निवारण के लिए पेंशन विभाग पेंशन अदालतों का भी आयोजन करता है, जिसके दौरान माननीय राज्य मंत्री स्वयं पेंशन भोगियों से बातचीत करते हैं। इन अदालतों में सभी संबंधित हितधारकों को आमंत्रित किया जाता है, जैसे मंत्रालय, विभाग, संगठन, सीपीओ और बैंक। उद्देश्य होता है याचिकाकर्ता को उनके लंबे समय से लंबित पड़ी शिकायतों के निवारण के लिए त्वरित समाधान प्रदान करना, जिससे न्यायालय या कैट जाने की आवश्यकता नहीं होती है। परंतु फिर भी विभिन्न कारणों से शिकायतें होती हैं और पेंशन भोगी कैट या न्यायालय को अप्रोच करते हैं। कोर्ट केसेस को डील करना अपने आप में एक चुनौती होता है। प्रायः देखा गया है न्यायालय के समक्ष नियमों को सही तरीके से प्रस्तुत नहीं किया जाता है, जिसके परिणाम स्वरूप मामले लंबित होते हैं और पेंशनर तथा अन्य पक्षों को काफी असुविधा होती है। और इसीलिए पेंशन एवं पेंशनभोगी कल्याण विभाग द्वारा आज की इस राष्ट्रीय कार्यशाला का आयोजन किया गया है, जिससे सभी स्टेक होल्डर्स के बीच बेहतर तालमेल स्थापित हो सके और सरकार के सुशासन के संकल्प को साकार किया जा सके। सर्वप्रथम ओपनिंग रिमार्क्स के लिए हम मंच पर सादर आमंत्रित करते हैं पेंशन विभाग के संयुक्त सचिव महोदय आदरणीय श्री ध्रुव ज्योति सेन गुप्ता जी को। सर, आपका बहुत बहुत स्वागत है।
धन्यवाद मंजू जी. Secretary Pension Shri V. Srinivas, learned at ASG, Additional Solicitor General Shri Vikramjit Banerjee, Shri T.P. Singh, our learned Government Counsel, all senior officers from respective ministries, departments, directors, then senior officials, and all officials who are dealing with pension and service matters, press and media friends, colleagues, a very good morning to all of you. We are very fortunate that we could hold this workshop because this has been on the anvil of the department for a very long time, because we are one of the most litigated departments. We deal with a huge amount of litigations, and handling the litigations has been a major challenge to our department for a very long time. Our case laws have been evolving on these issues. We have been facing contempt. Our Secretary Sir is personally in contempt. Every now and then there is some case which crops up suddenly, and then it is running towards our government councils, ASG, and to seek advice and then get going with the court case. And many a times this expectation goes so beyond that it is very difficult for us to submit to the courts that we have nothing to do with that case. But since from the government side, Government of India side, pension, the word pension itself gets associated with our Department of Pensioners, Pensions and Pensioners Welfare. So we have been owning up a lot of litigation cases. We have been owning up a lot of case laws. We have been hand-holding a lot of departments and ministries in this. So based on that, this is a very concrete step that under the guidance of our Secretary and our Honorable Minister, that we took up this national workshop, and I must say that there has been overwhelming support. As you can see, the hall is almost filled up, and I am told there is a huge gathering outside at the reception gate. So as people are pouring in, I'll just briefly mention what is this workshop, how it is structured. I would mention a small line from Dr. Bhimrao Ambedkar's many such pronouncements regarding law, that indifferentism is the worst kind of disease that can affect people. So if you are indifferent and we are indifferent, then that cannot be solved. And you will find, as the legal experts speak in today's sessions, that many a times it's indifferentism that takes us into real complex situations as far as litigation is concerned. So this is the first national workshop and has been organized under the aegis of this ministry. I would like to put on record the overwhelming response from all the ministries, departments for nominating concerned officials, for whom the value proposition of this workshop is meant to be. It is to drive home the point that court cases and litigation need to be handled with promptitude. It has also a goal for getting a closer understanding that simpler rules and procedures and transparent systems are the key enablers towards better legal management. Also, I need to thank Secretary Sir for his vision and guidance in curating a novel initiative in this department, which we feel is so relevant and contextual. The workshop is for half a day, as you would be aware. There would be 2 technical sessions, followed by a plenary session at 12:30. The details are in the minute-to-minute program in your folders. We are very happy and enthused There is a sizable section of the judicial fraternity is also part of this proceeding. In fact, we requested Secretary Law, and she has been very kind enough to nominate a team of government councils dealing with service matters, sir, who would be part of the proceedings. So I would urge each one of you that each technical session would be followed with a interactive session. Please feel free to interact, because the whole purpose is consensus building among stakeholders, better management of litigation, deeper understanding of why pension is so much litigated, and a coherent narrative of Government of India for handling pension cases. So those are the takeaways that we are aiming at from this workshop. I once again wish every one of you all the very best for today, and make full use of this workshop. We will have luminaries from the judiciary who would be speaking to you, and the plenary session also. So thank you very much, and have a very nice day with all of us. Thank you so much. Jai Hind.
थैंक यू सर। केस लॉ महत्वपूर्ण सेटल्ड केसेस होते हैं जो वर्तमान में चल रहे कोर्ट केसेस में महत्वपूर्ण भूमिका अदा करते हैं, और इसी क्रम में पहले तकनीकी सत्र का विषय है पेंशन केस लॉ। इस विषय पर प्रकाश डालने के लिए हम मंच पर सादर आमंत्रित करते हैं आदरणीय श्री विक्रमजीत बनर्जी सर, लर्नड एडिशनल सॉलिसिटर जनरल। आप NLSIU बेंगलोर के पहले स्नातक हैं जिन्हें इस संवैधानिक पद पर नियुक्त किया गया। आप विद्वान लेखक और शिक्षक भी हैं। आपने NUJS और IIM कोलकाता में अध्यापन भी किया है, और विधि एवं नीति संवादों में देश की एक प्रभावशाली आवाज बने हुए हैं। बहुत बहुत स्वागत है श्री विक्रमजीत बनर्जी सर का, आपकी तालियों के साथ।
अच्छा, मेरा एक प्रेजेंटेशन है, पावर पॉइंट चल रहा है? अच्छा, that's I don't know how to change it. I'll say next slide, next slide, next slide. अच्छा, thank you. Learned Secretary Saab, Joint Secretary Saab, thank you for inviting me, and it's a pleasure and honor to be here. I think this is a wonderful idea, और आगे ये सारे के सारे चीज़ लेके हमें आगे बढ़ना है, क्योंकि as Joint Secretary Saab correctly mentioned, that there seems to be a large number of litigations, especially in the areas of pension. I was just informed by the Learned Secretary that there seems to be 60% of supposedly our matters in the Central Administrative Tribunal deals with issues of pension. So in some way or the other, we will have to find our way out of this issue. We face it every day, and as a result, it requires deep knowledge. Okay, thank you. Okay, thank you. So it requires deep knowledge, and this is a wonderful start for us to be able to have an in-house sort of meeting, so that there is an understanding of what are the broad principles. My presentation is not going to be a deep principle. There are two other presentations which I think is on litigation, which I think is going to go into further details. My presentation is more or less going to be on policy, and I'm not a great expert personally, I must say this, on the area of pensions per se. But nonetheless, this is going to be a small presentation of what are the major case laws on pension, Some of my friends whom I recognize are from the courts, and I'm sure to them this is almost de rigueur in some ways. These are first principles. So we are just going to discuss the first principles, because I think this is, for most of us are not too aware of the case law, so this is just stating the broad first principles. And then I can see Mr. Singh, there is going to be next sessions where all this you can discuss and you can put questions. There is a long sort of history in the areas of pension in this country. It's not a new idea. There has always been in this country of a history, and this is just, I wanted to flag this. This is not, pension is not a Western idea per se, but there has been a long history in our country, as mentioned in this slide, including in the Arthashastra, which said very specifically that pension needs to be paid for those who are incapacitated and those who have something to do with the state. Now, in the Western system that we are aware, that we sort of deal with today, it starts off again as background put in from the time of Augustus Caesar, where for the first time in around 1st century BCE, there was a fixed pension for the soldiers of the country. So that's the first sort of where we see it in history. Now, thereafter, most of it is, as we know, was given because at those times the kings wanted to be on the right side of the army and the civil servants, because it is based on them that they remained in power. But there was a substantial shift. I think this is the next slide. There was a substantial shift in the 19th and 20th century when pensions were put into codes, and effectively they were democratized. And this was also due to, at those points of time, there was largely democratic uprising within the society. So it became, in some ways, the formal system that we are aware today. Now, just as a background, because we are all lay people here, so this is as a background, the first sort of pension as we know it was started in Germany in 1889. Anyone who is aware of Bismarck, the great Chancellor of Germany, Bismarck, started it. And you also have to realize 1890s and 1850s onwards is the age of the Industrial Revolution. And there's a huge amount of workers' outpourings, workers' demonstrations, which are happening all over Europe at that point of time. And Germany, Karl Marx is from Germany, in and around that same point of time. There's a huge workers' outpouring because it's a hugely industrialized state. So therefore, for the first time, and as you know, there were no workers' rights. There were small kids who were working in factories. There were very old people who were working in factories. And there was a huge movement that workers' rights had to be incorporated in some way or the other. So the first sort of workers' welfare legislation was introduced in Germany for pension, contributory pension for workers over 70. And the United Kingdom in 1908 came up with the first Old Age Pensions Act, which was, again, non-contributory pensions for the elderly poor. So it was one step further. So you didn't have to contribute. The state contributed, and the state ensured, especially workmen were compensated, for people who were old were compensated without any contributions on their behalf, and this was funded by taxation by the state. Again, the reason was, this was all part of the Great Industrial Revolution, huge amount of workers' movements, which were all across Europe, especially in factories. So there were concessions which had to be given to workers. Anyone who knows 1908, the churning in Europe, and especially as to industrialization and workers' rights, were happening in front of everyone. Now, that world largely is gone. You would barely be able to recognize Europe, and you barely be able to recognize the Europe of factories. There are barely factories left in Europe. But all these changes actually started in a concerted manner at that point of time. Now, let's come to the main question about India. The pension framework, as we know it today, starts in the colonial era. It starts in the Royal Warrant of 1870, which applied the British rules of pension, which the British were looking after their civil servants, to the ICS. It defined the retirement age and defined the ceiling of pension. Because as we are all aware, before that, the pension regime in India was completely fragmented, even during British colonial times, because there was the British East India Company, so there was this complete sort of disjointed structure of both employment as well as people who were working with the government, the military service people who were working with the government. Everybody had their own different pension regimes. So for the first time, the Royal Warrant in 1870, which reforms the British civil service actually, and sort of fixes their pension, fixes the pension also for Indian civil servants and top military officials at that time. Both pension as well as their terms of employment. The next and the most important part is the Indian Pensions Act 1871, which codified pension rights, conditions, commutation, and forfeiture. This is basically the source of all pension legislation as we know it today, including medical benefits, including people who have retired because of them being incapacitated, they are to be paid, what are the rights of people, you can commute your pension, put it together and commute it. All these, the pension law as we know it today, starts off in terms of this act. So that's the genesis of most of pension law in this country. Now, I don't know how many of you can read it. I'll try to. Now, sort of what are the big legislation, what are the big framework that we sort of see as to payment of pension? And we'll put it chronologically. So in 1951, there was the All India Services Act. In 1952, which you all know, which is not the subject of discussion in this workshop, is the EPF Act, which sort of comes up with this entire Provident Fund scheme. In 1972, the Central Civil Service pension rules comes into effect. And then these three famous schemes which we all know, which is so often litigated, is the three pension schemes. The 1995 Employment Pension Scheme. In 2004 is the National Pension System. The 2020 is the Code on Social Security. I think it's still in the works, still parts of it being notified. 2021 is the CCS NPS rules, which is the National Pension System rules are put into effect. In 2025, I've been told, there may be a unified sort of pension scheme. Now, the entire discussion is, of course, whether you are going to have a fixed payment to be made, whether it is to be contributory, or whether there has to be a guaranteed payout. That's broadly the schemes which you will discuss. That's the policy of the government, and when the government will come out with details of the policy, that will be implemented. But in my case, in the presentation, crux of the presentation, now what are the broad principles of pension law? The first case, which I would like to suggest to you, there are a large number of them, as some of my friends are here are aware, and there are in fact too many of them, but I'll try to state the broad principles here so that I'm sure most of us are aware of. But nonetheless, for those who are not aware, these are some of the broad principles. In Devkinandan Prasad versus State of Bihar, pension was denied post-dismissal, and the state argued, as everybody knows is one of the fundamentals of pension law, saying that pension was not a right. The court very famously held that under Article 31, which is at that point of time the right to property, which is now Article 300A, said, interpreting that is that pension was not at the discretion of the state. Now you will, whenever all of us who appear in court regularly knows that that is a fundamental argument which we are faced every time we go to court. Because the eventual argument of everything boils down to, pension is not at the discretion of the state, and you cannot deprive us of pension. Pension is a right, effectively. This is the case again, which is very hotly discussed, which again is a huge, is the basis for a lot of litigation which happens, is DS Nakara versus Union of India, which is a very famous constitutional decision in itself. As an aside, if I recall, DS Nakara also, something which all government officials who deal with the law is aware, brings in that the right to equality includes non-arbitrariness. That's one of the principles of DS Nakara, but it was a pension sort of case, so we deal with the pension issues. And we know that whenever government policy is basically challenged nowadays, it's challenged on two grounds, on it being unreasonable and it being arbitrary. And these are the principles which basic DS Nakara, anyone knows, comes up with. Now, DS Nakara sort of deals with the liberalized pension denied to pre-1979 retirees. And the challenge was as to the date-based classification, as to, how can you exclude people, how can you include people. The court came to the conclusion that the classification violated Article 14 and failed the twin test of intelligible differentia and rational nexus. And while deciding that, it laid down the entire principle that no classification or no principle of law or no government action could be arbitrary or unreasonable. So in many ways, DS Nakara lays down that constitutional principle and also lays down the basis of pension jurisprudence. Because pension jurisprudence by nature, at least on the side of the government as side of lawyers that we appear on behalf of, litigation deals with exclusion of some and inclusion of the others, of some others. That's the basic, because someone wants those benefits and you are saying this is not available to you, these benefits are available to you. For that purpose, in most litigation, DS Nakara would be cited. And there, of course, would be some latest judgments would also be cited, but the principle cited would be DS Nakara, as we know, saying that you cannot exclude us, your exclusion is arbitrary, there is no reason why you are excluding us, and we have the right to this pension. Next is A.P. Srivastava, 1995. Now, the issue fact was there was compulsory retirement, and pension was denied, though the qualifying service was met. The court held that the compulsory retirement does not disentitle pension if service conditions are satisfied. Now it goes back to, again, the original principle where once the court decided pension is a matter of right and you can't just randomly deprive pension, it's not at the discretion of the state. This is literally a corollary of that. The corollary being, if you've done your service to the state, the thinking is this, that if you've completed your service to the state, even though, and you had there was that compulsory period, which, as all of us know, to qualify for pension, you must have that compulsory period. If you fulfill that compulsory period, the state cannot deprive you of pension. Then in 2006, there is Colonel B.J. Akara versus Government of India. Now, this is something which I think we are all dealing with now and grappling with in very many ways. Once there are a number of schemes that we sort of discussed, is pension disparity due to different retirement schemes. Now, this was upheld. Now, the fact that you could come up with different schemes. Now, the obvious argument, as we've all said, and it works, I think, from the persons who are getting pension, saying that, why do you discriminate? Why do you, and I know this debate is, let's go back to the old pension scheme. Let us go back and, go back. Why are you discriminating between two different schemes? And whether you're entitled to come up with two different schemes. The court in Akara said that you could come up with two different schemes, and merely because there are two different schemes does not make it unreasonable or discriminatory. Now, this is, the next is All Manipur's Petitioners Association versus State of Manipur. This is of 2020, which was revised pension benefits denied to pre-1996 retirees. Those who, the revised pension was deprived to those who were retiring pre-1996, which was struck down. This is the flip side of that argument, saying that you have to have a basis of that classification, or why you're excluding some and including some. If you fail that test, and which we as litigators will come up off very often, then sort of they're liable to be struck down. And in many ways, as you, as part of the government, when you brief the lawyers, and most of our litigation will be around these issues, as to why, again, exclusion, inclusion schemes, I would request you, as a lawyer who has appeared frequently, that you have to be able to justify and give reasons. So that homework needs to be done for us to be able to sustain these provisions, which are perfectly legal. The court says they are perfectly legal, you can discriminate, but there has to be based on some reason. If you don't stand on some reason as to, cut-off dates, you have the discretion. Let me put it this way. Don't get me wrong. You do have the discretion to fix cut-off dates. There is a large number of Supreme Court judgments which says that you have the discretion to fix cut-off dates. But you also have to come up with some reason as to, what is your position as to why you've taken certain decisions, why you have not made it available to others, what was the reason for the new approach in terms of the new scheme. This is, of course, for the High Court judges. Now, this is the suo motu writ petition 4 of 2024, where unequal pensions for retired High Court judges based on tenure and source. Effectively, there was a direction for one rank, one pension for judges. Now, the judges themselves have, just as an aside, have moved towards trying to get some sort of uniformity of their own pension ideas. Now it comes to the S30 Pensioners Association versus Union of India. This is in itself, I don't know how many of you know, this is quite a lot in debate now. The issue, in fact, was commutation denied to similarly placed pensioners based on retirement date. So there was a claim in S30 that we've retired on a certain date, and I won't go into too much details because this is not the place for discussing all that. And since you can't basically discriminate between batches, effectively. That was the argument. The court said that you can't. Now, of course, this has been remedied by an amendment in the law which takes back, which sort of gives the government to have the right to sort of, in many ways, differentiate and not discriminate between different batches depending upon service conditions. This is now pending before the Supreme Court, and we will see how and where that goes. Of course, there is this, I think the last, there is obviously the duty towards one's people, and therefore the government is conscious of its duties, and it is conscious of its duties towards its workers, to people who have worked for it. But then we also have to realize that the government works within its means. And there are financial constraints. And so the entire sort of work of the government is to balance these two interests while making available pension, which I think is a right, which I think is available to everyone, and rightly so. It is also constrained by the economics of the situation. So as everyone knows, the development of the pension schemes itself first was a fixed pension scheme. Then the question arose that if it is a fixed pension scheme, what happens to the economics of it, because of the fixed payout and a large amount of government resources were invested in it, as well as there were a number of economic reasons. So then it came to a contributory pension scheme, and in which, again, the law was that people would contribute, and depending on contribution, they would get their payments. Now there seems to be some sort of outcry against that, so that if that is to be reworked. So I think these two things, and I'm talking to you because you are government employees who deal with these issues. You are not only, in two aspects you're here. You're both here as government employees as well as employees who deal with pension. So you're affected on one side and you're deciding the issue on the other. So I'm just saying this, and I'll say this in conclusion, that in implementing the policy that you are going to, and I've just laid out the broad sort of contours of the law, you will have to ensure that the interests of the government is protected, as well as the rights of the pensioners are looked into. There is, of course, development on case-by-case basis. And the court at times, as you've seen in a large number of judgments, and sometimes come on one side and sometimes on the other, but has preferred in many ways sometimes the rights of the pensioners. And rightly so. There has to be, I'm of the view there has to be sympathy for the pensioners, because of course they have given their life for the government, working for the government. So I would only request you to, the next time when you brief your lawyers, and there are, I can see a lot of them here, that you do come with the reasonings, and that's what we as lawyers expect from you. Thank you very much.
Thank you, sir, for your kind words. सर, आपका एक बार पुनः आभार. आपने निमंत्रण स्वीकार किया और हमारे सत्र में आपने पधार कर हमारे सबका ज्ञानवर्धक किया. बहुत बहुत धन्यवाद. अब पेंशन संबंधी विषयों पर प्रकाश डालने के लिए हम इस पैनल के अगले स्पीकर आदरणीय संयुक्त सचिव श्री ध्रुव ज्योति सेन गुप्ता जी से निवेदन करते हैं।
Okay, so thank you, Shri Banerjee, for setting this ball rolling for pension case law. And very rightly you have pointed out the major milestone judgments which have affected the evolution of pension case laws. And from the department, we feel, because we are the department who deal with policy, we deal with the litigation portion, we deal with interpretation of all our pension rules, and more often than not, many of our rules are set aside by the honorable courts for reasons which are there in those judgments. And it's a learning process for the ministry also. This process is going on, and as new pension schemes are getting rolled out, now the unified pension schemes, pension scheme has been rolled out, we are on the job of getting the rules framed, and it will come out very soon. We, from the government side, we feel very strongly that we make a law, we make a rule under Article 309 of the Constitution, and it should be, easily interpreted, it should be easily implemented across all ministries, all departments, because we deal with civil ministries. We are not so much into the defense pension, and the pension which is basically to autonomous bodies and state governments. Though, ironically, most of the state governments and the autonomous bodies, they follow CCS pension rule and the rules which we frame, and they adopt it in their own ways. And here is a question where the court finds it very difficult that there is a OM office memoranda of DOPPW which comes up for discussion, which is challenged in one of the court of law, and the department in the rule book itself, we have mentioned in the second para that it does not relate to state governments, it does not relate to autonomous bodies, it does not relate to defense pension. But those rules are quoted, those office memoranda keep on coming up because they have been adopted by those authorities, administrative authorities, and thereby the interpretations vary. Interpretations vary from court to court, they vary from body to body because of these administrative differences. And you can understand, standing in Delhi or sitting in our office premises at Delhi, defining a pension law and to implement the same in the same structure, same theme across the entire machinery of government is a different ball game altogether. So I'll raise your thought a bit by quoting again Dr. Ambedkar, where he says, unlike a drop of water which loses its identity when it joins the ocean, man does not lose his being in the society in which he lives. Man's life is independent. He is born not for the development of the society alone, but for the development of his self too. And that's where pension comes into purview, that after he or she goes into retirement life, and whatever Shri Banerjee was saying, that government has a duty, as he was quoting Manusmriti, to protect, to give social dignity, security, to give livelihood when something untoward happens to the pensioner, to his family members, daughters, children, spouse, dependent parents, the entire gamut. The pension, it doesn't only affect the individual, it affects the entire family, as well as through the families, the entire society. We understand, we do understand. And so the mission and vision of the Government of India, and especially Department of Pension, is towards dignity of pensioner. We are evolving the case laws on the basis that dignity of pensioner is maintained. Social security is the priority. Ease of access, thereby meaning that if you are a pensioner and if you have something to ask, there is a question in your mind, we are accessible, our stakeholders are accessible at the very first go. We are looking towards a lot of digital empowerment through our rules itself. The civil pension is processed through Bhavishya. We have similar portals on defense side, the railway side, the postal side, telecom side. We are moving towards digital, and we have moved a lot of ground, you understand, and digitization and digitalization both have a very far-reaching impact in getting this access, getting this real-time feel. Suppose a dearness relief is announced, the next month the pensioner has to get that. Otherwise, he feels cheated, he feels breached. And next is the qualitative redressal of grievances. That has become a major priority and a driver which is linked directly with litigation. If we can resolve grievances, we understand that immediately it has a far-reaching impact on not only the litigation factor, the aggrievement, but also on related issues, related pensioners. They feel that yes, this redressal is there. So the value proposition, what we understand, is a policy that is guided toward to protect rights, as Shri Banerjee was mentioning, dues of pensioners, standardize and obviate oversight. That also is being looked after by the ministry, both for NPS as well as OPS. And gradually to evolve a regime that each pensioner gets his or her dues in time, correctly computed, and, which is most important, effectively understood by him or her. If he or she doesn't understood the computation, there lies a sense of discrimination. The seed starts developing from that point. So, spate of judgments which arrive with where we are parties, all the ministries are parties. They're varying in nature, texture, content, reference, but the underlying principle is pension policy. So you need to go deeper in the understanding of pension rules to be able to implement them in a way that is in the spirit which the government has rolled that law or that rule for. So making pension policy, pension law, we look at these basic precincts of what is affecting the most, what is litigated the most. We have 31 odd, reasons why grievances reach us, and we continuously try to analyze. So the urge is that the persons who are handling pensions kindly try to analyze what is disturbing the pensioners, what brings sense of parity, and what is the target group. Like, for example, we have a classic example of an unmarried daughter of a Mali residing at a very remote corner of the country. The targeting that pensioner and targeting somebody based in Delhi is completely different. So that is why in our case laws, the evolution takes place with a lot of consultation with all stakeholders. And we do have all these stakeholders which I have listed out, pensioner welfare associations, we have interministerial meetings, especially DOE, DOLA, and UPT. Then there is serious political direction also towards, as I would briefly mention, in family pension you will find. So we want to develop a transparent and proactive policy that has flexibility in imbibing change and providing justice, so that we evolve pension policy accordingly. The procedure, we all know about it, but just to reiterate, this is the procedure for making a pension case, and through a pension case, a law. The concept generates, then the drafting of the rules, then the consultations begin. Those consultations, through those consultations, the modifications to those drafting is done, then consensus is built, and then final sanction. And you can understand this entire process has multiple stakeholders into it. So once you have a case law defined, either because of a court judgment or because of some legislation which has come, please read it carefully, because there's a lot of thought, lot of consensus building which has happened behind it. So policy, the evolution, as Sri Banerjee traced the history of the pension laws, it was 71, then 72, then 21, and we have the INPS rules, and we want definitely the UPS rules to be coming out very fast. So this is the evolution. So I'll take you through just briefly 2 minutes, 3 case laws which has evolved in our department and everybody is aware. One is the NPS to OPS, where once the NPS was rolled out, there was a lot of questions which came into picture. At what date, whether an advertisement before that date would be counted, whether a service which has had effect because of an advertisement which was before NPS, the person joined there, then traveled to central government, whether that has to be counted as old pension scheme. You can find a whole list of OMs coming out from our department, which is basically trying to understand the perspective behind each of those, either a grievance or an application or the scenario, by way of which we have evolved, and it is still evolving. The third from the bottom, the OM of 3/3/2023 is one of the OMs where we get references almost on a daily basis till date. And you can understand the NPS was rolled out in 2008 with effect from 2004, and the rules came out in 2021. So almost a span of more than 12-13 years was spent, whereby only directions had come out. So that has led to a lot of evolving factors which we are still developing. The second case law is family pension. All these OMs, they try whatever basic precincts I pointed out in my first 2-3 slides, of parity, of social security. All these OMs in the last, say, 10 years, they have been framed on the basis, on the principle of social justice, security, dignity of family pensioners. Whether it is for a certificate, who is competent to issue a certificate for invalidation of a pensioner, or a divorcee who has filed a divorce suit within the lifetime of the pensioner, or it is how you calculate the income criteria for reducing the eligibility of the family pensioner for family pension. They are all aimed towards bringing parity, bringing equality. But as Shri Banerjee was mentioning, we must understand and we must decipher who is equal to what. That has to be driven in, and that has to come out. So this is the second case law which I wanted to bring to your notice. And the third case law is again a recent case law. I'm sorry for the font size because I wanted to make it brief, but at least the basis I will share this presentation with all of you. This is the Rule 37 amendment which has come out very recently based on Honorable Supreme Court judgment. This was a case where the absorbee went from the central government to a central PSU and got absorbed there, and then got into a defalcation case, and there was a criminal proceeding which is there. Now, the earlier rule said that there would be no effect on pension which was part of the government service. That was set aside by the courts, and we now have the amendment which has brought parity between the absorbees as well as the government employees who are continuing in government. So now if there is a disciplinary proceeding or a criminal proceeding, the absorbees also has their pension affected of the government portion. So just to end that, whatever learned ASG is saying, that tracing the history as well as going through this entire gamut of pension law, you are the people who are interpreting law. You are the people who are briefing counsels in courts of law. You must have a very deep understanding of why, when, how this case law has evolved. So the department has been hand-holding a lot of pension cases, as I said in the beginning. You must be very clear on those issues, and justifying the word used normally by the pensioner is discrimination. The word normally used by the government is distinction. So the bridge between distinction and discrimination is the crux where a deeper understanding in pension case law would help a lot. So I'll end here, and I'll open up the forum. I think we have got around 5 minutes for brief interaction. If anybody wants to raise a point, so we will be more than happy. There's a lot of officers from the OPPW also deal with pension case laws, so feel free to raise any point. Thank you so much.
थैंक यू सर। अब समय है चर्चा परिचर्चा का। आज हमारे बीच यहाँ वरिष्ठ अधिवक्ता उपस्थित हैं, विभाग के काफ़ी सारे अधिकारी भी उपस्थित हैं, तो आप अपनी शंकाओं का समाधान करवा सकते हैं। अगर आपके प्रश्न हैं तो आप हमारे पैनल से पूछ सकते हैं।
माइक
No question is also dangerous. Either we have understood everything or we have not understood anything.
Sir, can we?
Yeah.
Yeah. Good afternoon, sir. Good afternoon, all. Sir, my little query was with learned ASG.
Please also introduce yourself.
Yeah. Sir, I'm Ankit Pandey. I'm in Ministry of Defense, Joint IFA, PIFA Q&M. We deal a lot with the, sir, pension and the disability pension, which happens there. Sir, I have just a request to you to throw some light on this retrospective date, because we have so many policies where we have a distinction that these will not apply. You show a case study also that retirees before 1196 or 1113. Generally, the Honorable Courts does not accept that, because you cannot have a distinction between these retirees and these retirees. So I will request some light on that. And sir, we are also seeing the Honorable Court judgment that this has to be done this way. If you are retiring somebody, it has to be a disability assumed of 20%. So these also we are seeing. So how to handle such cases, sir?
I'll just answer the first thing.
Yeah.
As Mr. Sengupta, and to answer the first question, is of the view that I am not completely in agreement that the court always strikes down that distinction based on date. The court usually does, but you have to make out a case for distinction. And I have seen some matters where the court has cited, and very strongly sided with the fact, as long as you have a genuine reason for distinction. So as lawyers, and I'm saying this as a lawyer, I'm not saying I'm taking the responsibility on myself. A lot of times we are handicapped by the fact that we don't have the reasons to put before the court. A court tests everything based on reason. That's how the court works. So if you don't come up with an effective reason, then the court automatically assumes that you don't have any reason, which is not true. Because as Mr. Sengupta said, you would have possibly had huge consultation. And I know, I have been in the government for such a long period of time, that nothing is decided off the cuff. But that's what it comes across to the court as. Okay? So that's the first part. So as from the Defense Department, we would expect that when you come to brief us on pension, anyone, you come up with reasons for those dates for schemes of application and things of that sort. I'm sure there are documents. There would be documents. There would be thinking. The second, as to question of disability pension, since you're from defense, you know how controversial it is. You know how Supreme Court has been taking us on that, and you know how we've been trying to come up with a policy in some ways which meets the scrutiny of the court. The court has its views very strongly, especially in defense. The court's view is disability pension. This person has fought for the country, he has suffered, he should get everything. Natural sympathy for soldiers. And I remember this conversation which I've had in court, especially in soldiers, where, after a heated argument saying that this can be distinguished, and et cetera, the Supreme Court judge turned around to me and said, Mr. Banerjee, these people have been fighting in Siachen. You have been sitting in this air-conditioned office and you're giving us this lecture. So I've taken that as well. So there is naturally even more sympathy, for soldiers, for defense personnel. And the court has been pushing this issue a lot against us. But that policy, that's being discussed as to, I think one of the courts, there was a suggestion of the court itself that every disability pension should have a scrutiny before you, before you grant it. Or even if you've granted it and an objection is raised, you should have an internal scrutiny as to whether you should be able to give it or not. They even suggested formulate a tribunal, like a scrutiny process like income tax, like the finance department does on tax matters. So, anyone can be, any claim for extra disability pension should be met in that way. I think we are in the process of looking into that, which should be both just and fair. But since you're from the department, you are also aware that there is also a tendency to take advantage of that. There's a certain section which takes advantage of that, especially in relation to incapacity, at what age you can retire, especially in the military. And there is a movement by people who have natural diseases because of the health condition to try to take advantage of people who suffered in combat. That I don't think is fair. The Supreme Court in some judgments have distinguished it. But there are other judges who are not willing to run with that. But that's also a matter of perspective.
Just add one thing here, because we are dealing with a lot of grievances also, and we have dealt with the extraordinary pension cases, and we have found in our ministry that one major issue which the court takes it against the government is delay. That if there is a case of disability, there have been cases where 3 times, 4 times boards have sat, again interpreted the same thing. 2 years lost in every sitting. So the person who is disabled, he gets his dues, say after 10 years, then he goes to court. It is very difficult to substantiate that he didn't have disability once the board has substantiated. And we have found cases that you have a empowered board to decipher it, then you stand judgment on that board itself. Then court will be definitely taking it on the other side.
Now, I'm just as an aside, now the court is of the view that even board's decision, unless it discloses reasons, and even goes far as to say at the time of your admission, if it hasn't been decided, if there was no specific observation that you had some sort of a disability which came out later, you were entitled to that. But that's the pull and pressure. The court thinks, at least the Supreme Court thinks, it's equity based, and it stands for the little person. So, as all of us know, I don't know whether I should say this, but the most difficult argument to meet in court is Garib ke upar atyachar, as any one of our lawyers would know. You can get over any argument, but you can't get over that.
Sir, I have a question. Sir, I am Ramesh Chandra Pandey from Ministry of Railway, sir.
Yes.
I have a question regarding disability pension to a dependent child. जो हमारा रूल बोलता है कि disability certificate डॉक्टर दे देगा. Based on that disability certificate, appointing authority has to decide whether that child can earn his or her livelihood or not. And on that basis, family pension will be decided. हमारे पास बहुत सारे क्वेरी आती है जोनल रेलवे से कि जो बेंचमार्क डिसेबिलिटी डिफाइन की गई है डिसेबिलिटी एक्ट में, दैट इज़ 40%. अब 40% का डिसेबल्ड पर्सन अर्न कर सकता है कि नहीं कर सकता, ये अपॉइंटिंग अथॉरिटी कैसे डिसाइड करेगी? तो डिसेबिलिटी should be decided by the doctors who are competent to figure out.
I understand that. I think I'm facing that exact question in another court, of Supreme Court. Decision is not out. We are arguing that.
Yes, sir.
I think there is a line of judgments what the Supreme Court and what the courts are doing. Why only Supreme Court? A large number of courts are doing. They are appointing their own doctors. They are not even satisfied with the department's doctors finding medical board.
Yes.
Because the argument is I cannot or I can, or not being able to do this. So the court is saying, okay, we'll appoint someone from AIMS, a board from AIMS, or board from the local hospital, which will go into whether they can do, whether they cannot do. Because again, this entire question of we are not being able to, as a department, being able to substantiate it. If we were able to substantiate it, I don't think this question would arise. And I'm saying that a lot of it is, of course, discretionary, as I said, balanced with Garib ke upar atyachar. Most of these cases would concern, and rightly concern, very small people and disability. So the natural sympathy of the court is with the little person against the big government, against what they think are unreasoning or unsympathetic instruments of government. Those who are not concerned about the poor. जो गरीब के, गरीब कहाँ पे खड़े हैं, ये लोग जानते नहीं हैं. May or may not be true, but that's a separate issue. So court takes that line.
Yes.
Good morning, sir.
Sir, further question is, sir, अगर disabled person is well educated and is 40% disabled. How that can person be denied?
But that the court decides now. Eventually, I'm talking about as a lawyer, eventually it'll go to the court.
I'm sure there are questions, and we'll have, Shri Banerjee would be here. So I'll request all of you to have time out when we are having lunch or the break also, because we need to move on to the next session also. So keep your questions. We will be definitely coming back to you, and I'm sure you would be having some opportunity of interaction. Yeah.
थैंक यू सर। इस सत्र के स्पीकर्स को सम्मानित करने के लिए अब मैं अनुरोध करती हूं पेंशन विभाग के निदेशक श्री राकेश कुमार जी से। आइए सर, आपसे अनुरोध है कृपया आदरणीय विक्रमजीत बनर्जी सर लर्नेड एएसजी को स्मृति चिन्ह भेंट करें। सर, आपसे पुनः अनुरोध है आदरणीय संयुक्त सचिव महोदय श्री ध्रुव ज्योति सेन गुप्ता जी को भी स्मृति चिन्ह भेंट करें। धन्यवाद सर। हम 5 मिनट का ब्रेक लेंगे, उसके बाद अगले सत्र के लिए हम सब यहाँ उपस्थित होंगे।
तो ये भी
पेश किए जाते हैं। यदि इसी स्टेज पर मामले को सही प्रकार से हैंडल किया जाए तो उच्च न्यायालयों में आगे और लिटिगेशन होने की संभावना कम हो जाती है। इसी विषय पर आधारित है हमारा आज का दूसरा तकनीकी सत्र, जिसका विषय है पेंशन लिटिगेशन इन कैट। इस सत्र के वक्ता हैं डॉक्टर छबिलेंद्र राव जी, ऑनरेबल मेंबर कैट, प्रिंसिपल बेंच दिल्ली। सर, गवर्नेंस रिफॉर्म्स में आपके उत्कृष्ट कार्यों के परिणाम स्वरूप डिपार्टमेंट ऑफ गवर्नेंस रिफॉर्म्स पंजाब को वर्ष 2012-13 के लिए प्राइम मिनिस्टर्स एक्सीलेंस अवार्ड इन पब्लिक एडमिनिस्ट्रेशन से सम्मानित किया गया। सचिव के पद से सेवानिवृत्त होने के पश्चात माननीय कैट में आपके सार गर्भित अनुभवों से आज हम सब प्रतिभागी निश्चित रूप से लाभान्वित होंगे। सर, आपका बहुत बहुत स्वागत है। कृपया हम सब का ज्ञानवर्धन करें। तालियों से स्वागत करें श्री छबिलेंद्र राव जी का।
Good morning, everybody. After the introductory session, you have the history of litigation regarding pension, but mine will be not exactly the litigation as such, because my experience is that I worked for 35 years in government, dealt with the establishment matters here and there, heard the grievances of people who are suffering from, you can say, the insensitivity of the establishment towards the pensioners. And subsequently, last 2.5 years, I'm trying to dispense justice as a member of Central Administrative Tribunal. And we have seen the way the litigation develops and why people come to CAT. There are, this is the scheme of my presentation. The first one is that even the legal position is clear to everybody who are dealing with the pension matters, or who will be deciding what is the amount of pension to be paid, when it will be paid, whether to be paid or not to be paid. They know the legal position, but there are certain issues. That is the first part I will be dealing with from my experience and from the experience of litigation in CAT. The second is there are certain administrative reasons why people don't get the kind of their grievance redressed in the system, and that's why they come to the CAT. The third is even somewhere, like in the previous session, you have seen, the legal position is not that clear. The people who are dealing with the pension cases, they may have some doubt. They have their own interpretations, and people are not satisfied. They go to the CAT, and subsequently High Court and Supreme Court. Then the last part is the way we deal with the litigation. There are judicial decisions which also encourages litigation. Being part of the judiciary, I have no hesitation to say so, because of my administrative experience and experience of 2.5 years in CAT. I said there are certain decisions which encourages litigation, or the system of judicial dispensation of justice also encourages sometimes. Now, let us come to the first part. it is the mindset of certain administrative authorities. I'm emphasizing the word certain. I'm not saying it is always, and all the administrative authorities have the same kind of mindset. Is the first thing is the empire strikes back. The person has served in the department. Some people might have been dissatisfied the way he worked. You might have robbed the person in the wrong way. Both your seniors as well as juniors, both political as well as non-political executive. Now it is time. You are retiring, we'll see. This attitude is reflected in many litigations which we find, though we don't write in our judgments that this is the reason, but it is apparent from the facts and circumstances of the case that on the last date of retirement, there is some kind of suspension, that is all okay, that is there. But there will be some disciplinary case initiated just a few days before the retirement, or your dues are not recovered, so you will not get your pension, or some other reason. So this is where they take, even they know the law position. They know that it is not legally possible to stop the pension, but they find ways and means to delay payment of a pension. They may not completely, you can say, deny pension, but they may delay pension. That leads to litigation. And next is the attitude of nuisance value. You know, some people, see, when we talk about, when Mr. Banerjee said about the Manusmriti, that the king has to look after the praja and the welfare of the praja. King in the modern democratic system, it's not a nebulous one entity. Starting from the lowest rung employee, that is the clerk, to the highest competent authority in the matter, there is a layer. So somebody somewhere has the attitude. You cannot say it is the government's attitude, or whoever is ruling, has his attitude. So you have to differentiate between the attitude of the people who are managing the affairs of the state. And there are layers, and some people maybe have their own attitudes. The nuisance value is that, yes, in public service, if you can relate back to, if you have read the novel Rag Darbari, 1968 novel, where Mr. Sri Lal Shukla got the Sahitya Academy Award for that novel. He has described a small incident pertaining to court cases. A person did not pay him, the person who deals with the court cases, the reader or somebody of the collector, some amount of his bribe or whatever he wanted. So the case came up, some date was announced, that this is the next date. But he noted down, but when the notice board came, the date was changed. The person, deliberately it was done, because he was not satisfied with the party. So a particular date was given. The person went back. He thought that I will come back on the next date. And when he came the next date, he didn't find his case. Then he asked, where is my case? He said, no, today is not your case. Then what is the date? No, I don't know. I have to look in the file and find it out. Ultimately what happened, he did not find his date, and the decision was decided expertly. And because it was decided expertly, he has to go to the next higher court. It took another 2-3 years to get back a remand order from the higher court. For not paying a few rupees to the reader, he suffered for 2.5 years. That is called the nuisance value. The person who is dealing with that. So in government, some people think that, yes, we have come to the government service, we have the power and influence to harass people. If you don't pay due regard, or Nazarana, then we have the power to harass you. These are facts of life. So one has to take into consideration. Now, that was part of the establishment. Now let us come to the litigants. There are habitual litigants. We have seen in the CAT corridors, we can identify the person. He will have around 10, 15 cases pending in CAT. He is the only person who is aggrieved by the decision of the government. And there are people, they say, yes, I was in the establishment, I was in the audit, I was in the accounts, I know. Whatever decision has been taken in my case is wrong. But he doesn't know that subsequently rules might have changed, or courts might have given a different interpretation of the previous rules. He is not prepared to listen. No, I have dealt with the case throughout my life, I know I am right, so he comes to the court. And then there are post-retirement pastimes. Many people we have found that they don't have anything to do after the retirement, and filing cases against the government or for his own case is one of the pastimes. But these are not rare cases. There are several cases like this. We have come across in our my 2.5 years of experience in CAT. Sorry. Now, then cases do arise due to administrative delay in processing the pension cases. The first thing is the service verification. Very interesting case in my case. After 35 years of service, about to retire in July or June 2020, my staff came, sir, will you prepare your case for your retirement? I said, yes, that is given, you have to retire. Then I said, okay, after a couple of weeks, I said, all my case is cleared. No, sir. Your service for 1985-86 for 3 months, 86 for 3 months has not been verified. I am Secretary of Government of India, served the entire life. Here in Government of India and Punjab, my service has not been verified for 3 months in 1986. Who is responsible for that? And for your information, many people who are about to retire, they run after offices to get their service verified, or some missing entry in GPF or GIS. Why? See, the question is that we pride ourselves as we are the IT superpower. Why all these things are not automated and automatically? Every year after the financial, like your ACR or APR is written, why your service is not verified? And whoever is verifying the service, if he has not verified, why his APR should be written? Why we should not have a column in the APR that have you verified? If you are competent to verify, have you verified the services of the people? Because this is the most important case for delay in payment of pensions. In my case, it was in our phase 2 training in Missouri. My batchmate was the director there. I rang him up. He said, you send a mail and we'll verify. Okay, because my batchmate was the director, the next day I got my service verified from Missouri. But suppose some other person would have been there, or some clerical person who has retired from service, he would run from pillar to post after retirement or before retirement. And that is the reason my colleagues from the service, 85 batch, that's my batch, they got a new system of empanelment as secretaries. 1984-85, they are merged together. And in one go, the people were empaneled as secretary. Why? Because previously, it was people, when they are empaneled, they have only 1 year, 6 months or 1.5 years left as secretary. After being posted, they will run after their retirement things. They didn't have time to look after the affairs of the state. So that is the reason they said now people should have a longer period as secretary, so they started from that year. That's why you are now having longer periods as secretary. Yeah. So people should not. It is the job of the establishment, whoever is looking after the establishment matters, they should do it, service verification, and IT should be effectively utilized, and vigilance clearance. There was a very interesting case from Delhi government. Somebody came in the CAT. They say his pension has not been paid because there is no vigilance clearance. I mean, why? Then I asked this gentleman who was appearing on behalf of the advocate on behalf of Delhi government, tell me, what is the legal sanctity of vigilance clearance? After the Janaki Raman case, you people might have known, there are only 3 conditions under which you have to deny the pensions, or you can give you can say provisional pension, not final pension, and gratuity can be withheld. Those 3 conditions are if the person is suspended, there is a disciplinary case where charge sheet has been issued, and the third is if there is a criminal case where the magistrate has taken, you can say, cognizance of the criminal case. Cognizance means the charges have been framed. These are the only 3 conditions where you can issue only provisional pension, and you can withhold gratuity. None of other retirement benefits you can withhold. There are 30, in the leave rules, there are 39, Rule 39 of the leave rules, where you can withhold leave encashment provided there is something to be recovered from the employee in a disciplinary case, but no other cases. But plain because there is no vigilance clearance, many times various authorities, they withhold payment of final pension. And that is why people suffer and they come to CAT. Non-due certificate, again, particularly for any kind of a non-due is for accommodation. Non-due also are other things like you might have taken a loan. There are the 2 cases one can think about. But why the Directorate of State, in my case again, the Director of State realized that in my previous posting in 2003 and 4, there was some technical occupation of a residence in New Moti Bagh, and I did not take position. It was a technical position, and I have to pay 3 months rent for that. That is pending. That's why you pay for that, otherwise you will not get your pension. 2002-3, why you waited 2020? What is the accounting system in a Director of Estates? Why they don't also apply the IT system? And any time anybody who has not paid the rent for a month, next month you should issue some kind of demand notice to the concerned office where he is. So what I say that pension reforms also should take care of these small things, but which matter a lot. Apply all sorts of IT systems so that there is effective monitoring of these kind of things, and there is no need of human intervention in service verification, vigilance clearance, and non-due certificates. administrative delay comes from now ambiguity of a DOPD and Department of Expenditure guidelines. When we issue guidelines, when we issue OMs, do we validate? Validation means you call the people like who are dealing with pension cases, give them a case study, let them solve it. Applying your OM, if you find that majority of them able to solve it, then it is valid. We never do that. We think that whoever is framing a rule in the department, maybe consultation with the Department of Law, we say that is the law department does not look into the subject, they look into the legality of it. So the subject is looked after the people who are framing the OM or the framing the rules. So validation is required. And if you recall, now subsequently 2025, it was taken into the Parliament. Why the confusion was there? Which old table, S29 or S30, which will apply in a particular case? There is no clarity. Example tables are given. In a case of a CAT and High Court, many judges, they recuse to deal with the pay fixation cases because they say it is beyond our understanding. So make the OMs, the rules clear. When you have the PA Commission recommendations, you accept, make it in a simpler language, and step by step, as far as possible, as many examples to validate also your OMs. Now, who revised the pension? Who has the final authority? Yes, you have a pension processing, you have the concerned DDO, ultimately it goes to the bank. But there is a lot of a gap in between. Take the case of the notional increments, the judgment which came from Supreme Court and subsequently accepted by the DOPT. But finally, a lot of litigations still coming to CAT because there is no clarity from one authority to other authority, and particularly the banks. Even you decide about, okay, this person is entitled for one notional increment, who will give the arrears? So somewhere these loopholes needs to be plugged so that people should not suffer. Now, coming to the litigation part proper, because all these loopholes, I say, nearly 20% of the cases in CAT pertains to pension cases. And 20% is not a small number. If these administrative matters are taken care of, these attitudinal aspects are taken care of, I think a lot of litigation will get reduced. But now let us come to litigation proper. Now, pension, how you look at the pension? It has been seen that the authorities, the administrative view is that it's the discretion of the government to pay pension. It is earlier it was thought of, it was a bounty to be given to the pensioner. But the courts have a different view. It is not a bounty. It is a right. It is a private property. This judicial view has come in State of Jharkhand versus J.N. Srivastava. This is the case, famous case, which is again based on D.S. Nakra. This was discussed in the previous session. Devakinandan Prasad, Iqbal Singh. These are the three famous Supreme cases which have been quoted in J.N. Srivastava case. And there it was held that pension is like private property. So if you are tinkering with the pension, you are not paying, you are delaying pension, payment of pension, then you have to follow due procedure. A due procedure, that's the principle of natural justice. You have to give notice to the person concerned. B, without statutory provision, you cannot delay or impound pension. So this is the difference between the administrative approach and the judicial view. Once there is no convergence in these two kind of views, there will be always litigation and you will get adverse decision from the courts. So never mind if you get adverse decision because you have a particular view which is not accepted by the judicial courts. Now, the second is not only the nature of the pension, but whether to recover, whether you are entitled to recover from the retirement benefits. The administrative view is that, yes, we have a right to recover if something has been wrongly paid to the pensioner. If he has been paid excess amount, we have a right to recover because the money has gone from the state exchequer. This is a very legitimate view, but the courts have different, they look into differently. You have the rule 7173 of old rules 1972 because we are dealing with a lot of cases under that. That's why I will be referring to 1972 CCS pension rules. But the corresponding clauses you can refer in 2021 rules. There you have the authority to recover some outstanding dues. But there is a timeline, only 24 months prior to that. That is never added to. If you will find that your audit party has made an objection, why they if you look in the Civil Account Code 7.4.1, there is also prohibition that you cannot refix the pay, which is more than 24 months prior to the date of retirement. But still, the audit party, they look into 20 years back, and we have many cases, 2006, from 2006 onwards, people have reviewed the pay, refixed the pay, and they have started recovering. So these are the problem. And the courts, particularly in case of Rafik Mashi, Daniel Thomas, these are the famous cases where the judicial view is that, yes, you have wrongly paid, but the employee is not at fault with. And the employee or the pensioner has the right to dignity of life. Right to life as well as the right to dignity of life. He needs a minimum amount to survive. You cannot just recover because 20 years back you paid him some excess amount. Now from his pensionary benefits you will recover. This has been denied, particularly in Daniel Thomas. In Chandi Prasad Vanyal and state of Uttarakhand, it has been said that yes, you can recover if the person has given an undertaking. That is also in Jagdev Singh, that is a Punjab and Haryana High Court versus Jagdev Singh. In that judgment, it has been said, yes, you can recover provided the employee has given an undertaking. That yes, if I have been paid excess, I will reap. So you take care of that. In many cases, you don't do that. That's why the courts, they take an adverse view. Even he has given an undertaking. If he has been given it under duress, then again courts will apply Daniel Thomas and Rafik Mashi, and they will not allow the recovery of. So in all these pension rules, what you say, the principle of natural justice, recovery, or you are tinkering, or you are delaying payment of that pension, please apply principle of natural justice. Courts are severe on that. If you have not given a notice to the person, they will not give a favorable judgment. See, the question is that sometimes we impose interest starting from at GPF rates. Sometimes some benches they give 12% or 18%. You find that yes, it was you cannot get a favorable judgment even for the higher courts, and you started implementing it. But somebody is responsible for that delay. Have you taken any action against them? Unless you take action against them, the message does not go. So that is where lack of accountability. So I think at this stage I will stop. And the famous case is MCD cases. We have several number of cases from MCD, Delhi. MCD does not have money to pay for pensions. They have everything to do except paying pensions to its retired employees. So that is the reason courts also take a severe view. So there should be some kind of sensitivity towards the suffering of the retirees. Somewhere our priorities also should be there. So with this note, I think I'll stop. Thank you.
थैंक यू सर। आपके इस सार गर्भित व्याख्यान से हम सभी लाभान्वित हुए हैं। सर, आपने बिल्कुल सही कहा कि यदि समय रहते विभागों मंत्रालयों द्वारा छोटी मोटी फॉर्मेलिटीज पूरी की जाती हैं तो सेवानिवृत्ति के समय पेंशनर्स को होने वाली तकलीफों से बचा जा सकता है। इसी नोट के साथ हम आगे बढ़ते हैं और अब मंच पर सादर आमंत्रित हैं आदरणीय श्री टीपी सिंह जी। आप दिल्ली हाई कोर्ट में सीनियर सेंट्रल गवर्नमेंट काउंसिल हैं और आपने कई महत्वपूर्ण केसेस में भारत सरकार को डिफेंड किया। हाल ही में पेंशन के S30 केस को सफलतापूर्वक दिल्ली हाई कोर्ट के समक्ष आपने प्रस्तुत किया। आपकी तालियों के साथ हम स्वागत करते हैं श्री टीपी सिंह जी का।
थैंक यू वेरी मच। Respected Dr. Jitendra Singh, Honorable Minister of State, yet to be joined, Sri R. Venkatramani, learned AGI, joined through BC, Sri B. Srinivas, Secretary PUPPW, Dr. Nitin Chandra, Secretary Ex-Serviceman Welfare, Dr. Ranju Rathi, Rana, Secretary Law, Sri Bikramjit Banerjee, learned ESG, Dr. Chabilendra Rawal, learned member, Administrative CAT Principal Bench, Delhi, Sri Dhruva Jyoti, Sen Gupta, JS Pension, all the nodal officers of different ministries and departments, Government of India, learned standing councils, and different panel lawyers, distinguished media persons, ladies and gentlemen. A very good morning to all of you. In fact, it's good afternoon, very good afternoon to all of you. I would like to start my discussion with the report of Department-related Parliamentary Standing Committee on Personnel, Public Grievance, Law and Justice of 31st December 2022, which points out the situation of litigation pending before the different benches of high courts, different benches of principal benches of central administrative tribunals. The committee reports points out that as many as 80,545 cases are pending in different benches of tribunal as on December 31st, 2022. The committee in its report point out that there are about 1,350 cases pending for over 10 years. There are approximately 3,716 cases. I'm completing. I'm told that I should be finishing in 2 minutes, so I'm going to be very brief. Approximately 3,716 cases related to pension pending in the tribunal. The committee noted that the mounting pendency of cases in CAT, and it felt that one of the major reasons for the delay is the non-availability of the sufficient number of members. Sanction strength, all of we know that 35 judicial and 35 administrative, more than 17 posts are still vacant. Or even Allahabad, Bangalore, Hyderabad, Jammu, Patna benches are operating with 50% sanction strength. Now I come into the issues involved in disputes in pension litigation pending before the different benches of CAT. Computation, sanction, and disbursement of retirement benefit, including pension, gratuity, and other related entitlements, are major areas of disputes which leads to the litigation before the honorable benches of the CAT. And the reason why these disputes arise is there are discrepancies in interpretation of pension rules. Second reason are delayed processing of pensions of the retirees. And third one, in many cases, there are denial of giving a benefit of pension. The now key aspect, I have analyzed the pension litigation in respect of the different aspects of the pension litigation. Some of I am trying to present as I have very little time as the Honorable Minister is reaching. So I'm trying to be brief as I can. Pension as a right, the Honorable Supreme Court has already explained by the learned ASG and ASG that the pension has been held as a right and it is not a bounty as it has been upheld in different case laws by the Supreme Court. Now, pension litigation frequently involves disputes over the interpretation of application of pension rules, regulations such as CCS pension rules, and there are litigation due to delay in sanction of pension. There are certain cases where family pensions are denied to the eligible members of the retirees who has already died. Next, I would like to bring out the observation of courts in pension on the issue of pension. First observation of the Honorable Supreme Court, which has already been discussed by the learned ASG in Devaki Nandan case, and some aspects has been discussed in DS Nakara. I would like to very briefly point out the Dr. Uma Agrawal versus the State of UP. In 1999, the court held that the grant of pensionary benefit is not a bounty but a right of employee, and as such cannot be denied without proper justification. So, DS Nakara has been discussed by learned ASG in detail. I am coming to very briefly the suggestions how pension litigation can be minimized. There are certain suggestions which I am going to discuss in very briefly. First, I would like to recommend that streamline the procedure, enhancing transparency by digitization and online portals, which are still going on, but it needs further improvisation. The comprehensive online portal for pension application, tracking and grievance redressal This should include features of document submission, a status update, and communication with relevant authorities of pension records. Digitization of pension record will help a lot in reducing the pension litigation in India. Next, simplified forms and documentation, standardized processes, regular audit and inspection will going to help in reducing the pension litigation. Conduct regular audit of pension process system to identify bottlenecks and ensure compliance with rules and regulation. Promote alternative dispute resolution related to pension disputes. In this area, the pension adalats are very appreciable step taken by the department. I would like to recommend to continue and expand the use of pension adalats as platform for resolving the grievances, improving awareness and accessibility. That will also help. Next, I would like to recommend training for government officials dealing with the pension issues. Training of officials involved in pension processing on the latest procedure and rules are very essential. Next, I would like to point out the provisional pension should be given. There are cases where it is apprehended that there may be delay. In that cases, some provisional pension and gratuity should be given so that the pensioner retiree does not suffer any hardship after retirement. And the discrepancy should be dealt promptly. By recommending these suggestions, I would like to wind up because I haven't told that I don't have much time to explain. Otherwise, I could have explained various case laws. Most of the cases which has been dealt by the learned ASG, and now I'm winding it up just because of time. Otherwise, I could have explained many more things. Thank you very much. Jai Hind. Jai Hind.
बहुत बहुत धन्यवाद सर। और हम क्षमा चाहते हैं कि आपके सत्र को थोड़ा छोटा करना पड़ गया क्योंकि माननीय मंत्री महोदय जी का आगमन होने वाला है। कुछ ही क्षणों में वे हमारे बीच पधारेंगे। अब हम निवेदन करते हैं कि कोई आवाजाही ना हो और साथ ही एक विनम्र अनुरोध, कृपया अपने मोबाइल फोन को साइलेंट कर लें। मैं निदेशक राकेश कुमार जी से अनुरोध करती हूँ श्री टीपी सिंह जी को मोमेंटो प्रेजेंट करें। डॉक्टर छबिलेंद्र राव जी को मोमेंटो प्रस्तुत किया जा रहा है। धन्यवाद सर। अब आपसे अनुरोध है टीपी सिंह जी को मोमेंटो से सम्मानित करें। धन्यवाद सर। धन्यवाद सर।
ये सब कर रखिए नीतम से पूछो ये सब कर इसी से पूछो 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 ओके अच्छा ये भी लगा हुआ है
माननीय मंत्री महोदय जी हमारे बीच पधार रहे हैं। आइए अपने स्थान पर खड़े होकर करतल ध्वनि से स्वागत करें माननीय राज्य मंत्री कार्मिक लोक शिकायत तथा पेंशन मंत्रालय डॉक्टर जितेंद्र सिंह जी का। नमस्कार महोदय। परम माननीय प्रधानमंत्री जी के पेंशन भोगियों के कल्याण के संकल्प को अपना सर्वोपरि कर्तव्य मानते हुए पुराने नियमों की बेड़ियों को तोड़ते हुए नए नियमों, नित नए सुधारों, नई नई पहलों और राष्ट्रव्यापी अभियानों से देश के पेंशन भोगियों के लिए सुविधापूर्ण जीवन सुनिश्चित करने के लिए प्रतिबद्ध माननीय राज्य मंत्री महोदय जी का सादर अभिनंदन है। माननीय आपकी ओजपूर्ण उपस्थिति हम सब में ऊर्जा का संचार कर रही है। माननीय आपकी ओजपूर्ण उपस्थिति हम सब में ऊर्जा का संचार कर रही है। हम स्वागत करते हैं लर्नड अटॉर्नी जनरल ऑफ इंडिया आदरणीय आर वेंकटरमणी जी, जो सुदूर द्वीप हवाई से हमारे साथ वीसी के माध्यम से जुड़े हुए हैं। सर आपका बहुत बहुत स्वागत है। मंच पर स्वागत है सचिव पेंशन एवं पेंशनभोगी कल्याण विभाग आदरणीय श्री वी श्रीनिवास जी का। सर आपका बहुत बहुत स्वागत है। सचिव पूर्व सैनिक कल्याण विभाग आदरणीय डॉक्टर नितेन चंद्रा जी का। सचिव विधि आदरणीय डॉक्टर अंजू राठी राणा जी का। लर्नड एडिशनल सॉलिसिटर जनरल आदरणीय श्री विक्रमजीत बनर्जी। ऑनरेबल मेंबर कैट प्रिंसिपल बेंच दिल्ली आदरणीय डॉक्टर छबिलेंद्र राउल जी का तथा संयुक्त सचिव पेंशन आदरणीय श्री ध्रुव ज्योति सेन गुप्ता जी का सबका हार्दिक स्वागत है। पेंशन लिटिगेशन पर आयोजित इस राष्ट्रीय कार्यशाला में आप सबका हम हार्दिक स्वागत करते हैं, अभिनंदन करते हैं। विभाग द्वारा पहली बार ऐसी कार्यशाला का आयोजन किया जा रहा है जिसमें भारत सरकार के विभिन्न मंत्रालयों, विभागों के उच्च अधिकारी, पेंशन लिटिगेशन डील करने वाले नोडल अधिकारी, वरिष्ठ पैनल लॉयर्स और सुप्रीम कोर्ट तथा हाई कोर्ट के जाने माने अधिवक्ता आज हमारे बीच उपस्थित हैं। आप सभी गणमान्य अतिथियों का हम हार्दिक स्वागत करते हैं, अभिनंदन करते हैं। साथ ही हम स्वागत करते हैं उपस्थित मीडिया बंधुओं का। सर्वप्रथम हमारा अनुरोध है आदरणीय सचिव महोदय जी आपसे कृपया माननीय मंत्री महोदय जी का स्वागत सम्मान करें। पेंशन भोगी कल्याण के मार्ग प्रशस्त करने वाले माननीय राज्य मंत्री जी का स्वागत आपकी करतल ध्वनि के साथ। धन्यवाद सचिव महोदय। संयुक्त सचिव महोदय जी से अनुरोध है कृपया आदरणीय सचिव श्री वी श्रीनिवास जी का स्वागत करें। धन्यवाद सर। महोदय आपसे अनुरोध है सचिव पूर्व सैनिक कल्याण विभाग आदरणीय डॉक्टर नितेन चंद्रा जी का भी स्वागत सम्मान करें। महोदय कृपया सचिव विधि आदरणीय डॉक्टर अंजू राठी राणा जी का स्वागत करें। पुनः अनुरोध है कृपया लर्नड एडिशनल सॉलिसिटर जनरल आदरणीय श्री विक्रमजीत बनर्जी जी का स्वागत करें। पुनः अनुरोध है कृपया ऑनरेबल मेंबर कैट प्रिंसिपल बेंच दिल्ली आदरणीय डॉक्टर छबिलेंद्र राहुल जी का स्वागत सम्मान आपकी तालियों के साथ। हमारी गौरवशाली भारतीय संस्कृति के अनुरूप आज का कार्यक्रम का शुभारंभ हम दीप प्रज्वलित करके करेंगे। हमारा विनम्र अनुनय है माननीय मंत्री महोदय जी आपसे कृपया अपने कर कमलों से दीप प्रज्वलित करें। मंचासीन गणमान्यों से भी अनुरोध है कृपया दीप प्रज्वलन के लिए पधारें। आज का कार्यक्रम सार्थक, सद्भावनापूर्ण और हम सब के लिए लाभकारी हो ऐसी मंगल कामनाओं के साथ अब हम दीप प्रज्वलित करते हैं।
शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः
कोटिशे धन्यवाद माननीय मंचासीन अतिथियों का भी आभार। परम माननीय प्रधानमंत्री जी के सुशासन के संकल्प को सार्थक करने के लिए पूर्णतः समर्पित माननीय राज्य मंत्री जी के नेतृत्व में दूरदर्शी प्रशासनिक सुधारों का क्रम निरंतर चलता रहता है। इस दिशा में पेंशन भोगियों की शिकायतों के निवारण के लिए विभाग द्वारा पेंशन अदालतों का आयोजन नियमित रूप से किया जा रहा है। एक कदम और आगे बढ़ाते हुए इस कार्यशाला के माध्यम से होल ऑफ गवर्नमेंट अप्रोच के साथ विभिन्न हितधारकों में आपसी समन्वय बढ़ाकर लिटिगेशन को कम करने का प्रयास किया जा रहा है। औपचारिक स्वागत संबोधन के माध्यम से मंचासीन विभूतियों का स्वागत करने के लिए हम अनुरोध करते हैं पेंशन एवं पेंशनभोगी कल्याण विभाग के कर्मठ तथा दूरदर्शी सचिव आदरणीय श्री वी श्रीनिवास जी से।
Honorable Minister of State for Personnel, Public Grievances and Pensions, Dr. Jitendra Singh ji, my distinguished colleagues, Dr. Anju Rathi Rana ji, Dr. Jitendra ji, Dr. Chabilendra Raul ji, learned ASG, Shri Vikramjit Banerjee, my colleague, Dr. Shri Dhruvjyoti Sen Gupta ji, nodal officers of all ministries and departments, respected Attorney General of India, who's joining us all the way from Hawaii today and has accepted my invitation. Thank you very much for joining us at this hour, sir. We're extremely grateful to you. The workshop, and let me extend a warm and hearty welcome to Honorable Dr. Jitendra Singh ji and all the distinguished invitees on this occasion. The Honorable MS had addressed a media conference on 11 years of successful achievements of government, and it was also a phase wherein which several achievements of the Department of Pension and Pensioners' Welfare were highlighted. Let me take a few achievements that pertain to this workshop. In fact, it has been a phase of extraordinary and progressive legislation which witnessed updation of pension laws. The CCS pension rules 2021 were launched by MOSPP from the premises of Vigyan Bhawan on December 25, 2021 on Sushasan Divas. Thereafter, MOS had also launched the CCS NPS Rules 2021 and the CCS Extraordinary Pension Rules 2021. The integration of pensioner portals with banks was taken up in a mission mode approach, and almost all banks, including the State Bank of India, Punjab National Bank, were integrated. He had also chaired 19 meetings of the Pension Adalat, in which more than 18,000 cases were redressed under his leadership. And digital empowerment of pensioners has been a primary objective of the government, and more than 4.6 crore pensioners received DLCs. Some of the key issues that came up in the Pension Adalat, for example, the case of Jashodhan Devi, who received her extraordinary pension after a gap of almost 40 years, Anita Kania Rani, who received her family pension after a gap of about 23 years. Then the case of Saudamini that was discussed in the morning, which came after about 18 years, were all happened, and each of them had interacted with Dr. Jitendra Singh ji. I would also like to mention that under the leadership of the Honorable Attorney General of India, we have witnessed a series of progressive legislation which government has adopted in terms of updating its own laws. For example, on 3rd of March 2023, the NPS to OPS circular was issued in pursuance of the judgments of the Honorable Supreme Court to provide a one-time option to central government employees to opt for old pension scheme. Similarly, on 1st of January 2024, the female government employees could nominate their children instead of their spouses in case of marital harassment. The amendments in Rule 37 was something we had discussed in the morning. This came in pursuance of the judgment of the Honorable Supreme Court in the BSNL MTNL case. A few months back, I did receive a request from the first CEO of Niti Aayog, Srimati Sindhushree Khular, that an appointment for Shri P.C. Sharma, the chairperson of the S30 Pensioner Association, was to be taken up. Little did I realize thereafter that we were heading into a constitutional matter that would take almost 1,000 hours, in which more than 30 rounds of meetings with the Learned Attorney General of India and the Additional Solicitor General of India, the Secretary Law, the Secretary Legislative Department, Secretary Department of Expenditure, and of course the Prime Minister's office would be consumed in this formulating the validation of pension rules, in which government ensured that the existing legislation and decisions with regard to the 6th Pay Commission would continue to be maintained. In my interactions with the ASGs and Learned AG, I did come across the points that were mentioned today, that the ASGs and the panel lawyers who are participating today were not having adequate case details, and they had short timelines for filing replies. In fact, contempt cases were being taken up at the last minute, in which, in fact, there was one case when I was told at 9:30 in the morning that there is a hearing at 12:30 in the Ernakulam bench which requires your personal appearance. So this is the kind of urgency and last-minute mentions that were being maintained. So Department of Pensions on 15th of July had issued the guidelines that ministries and departments will make policy matters referred to the department at first stage. I would like to thank Secretary Law for the detailed directive for efficient management of litigation. And in the run-up to this workshop, we had taken several points from the directive and incorporated them. Let me mention a few. Streamlining administrative processes, reducing litigation of recurrent nature, reducing anomalies in statutory notifications and administrative orders, reducing unnecessary appeals, and put in place a sound knowledge management system and avoidance of contempt cases. In fact, in my numerous meetings with her, I came back with the feeling that technology is a huge force multiplier, and the LIMS portal that is maintained by the Department of Law and Justice is one of the most forward-looking instruments that can help streamline litigation. I also often emphasized in my discussions with Jitendra ji, I had told him that I am a party to about 6,000 cases in various courts. In fact, in one of the cases, Mr. Rawal had just ruled in our favor in a contempt case. But he told me that, Srinivas, you are not the only one. He is a party to 60,000 cases of pension litigation in defense tribunals. So we thought that we should curate this conference to enable nodal officers to strengthen capacities and ensure that the annual capacity building programs are taken up, as also to review applications in various CATs. This also is in accordance with the directive that has been issued by the Department of Law and Justice with regard to how we will handle litigation in the coming days. The roadmap forward envisages that the CCS UPS Rules 2025 would be taken up for interministerial consultation and would be issued in the coming days. Keeping in view what the learned Additional Solicitor General has said with regard to the quotation, Rajadharmena Krutva Prajna Sarvadharma Nyo Jayate. The king is governed. The kingdom has governed the kingdom in accordance with dharma and must ensure that its people fulfill their respective duties. So the family pension campaign, which has touched so many lives, would be taken up from 1st to 31st of July. We have tried to update the LIMS portal across all ministries, and today many of the cases, thousands of cases, have been reflected, and Secretary Law has discussed with me the forward-looking nature of having a next-generation LIMS portal that can enable effective litigation matters. We have cited as part of this discussion a huge number of pension laws and case studies. The learned ASG has pointed out the Nakara judgment, the Vains judgment, the Akara judgment, as also the Manipur Pensioners Association. The Attorney General of India would be best suited to explain how he sees pension litigation as a critical component of governance and how we should have an efficient pension litigation model. Let me thank once again each one of you for joining us. Let me thank the Honorable Minister. He's been traveling extensively and could make time to join us today. Sir, under your leadership, the most progressive era of legislation has been ushered in, and I hope in pursuance of this workshop, we will be able to improve the litigation management protocols in Government of India. Thank you very much.
बहुत बहुत धन्यवाद सचिव महोदय जी। अधिकांश कुटुंब पेंशन भोगी हमारे सेनानियों के परिवार के सदस्य होते हैं, जिनके पेंशन संवितरण में रक्षा मंत्रालय एक अहम भूमिका निभाता है। इस विषय पर प्रकाश डालने के लिए हम अनुरोध करते हैं सचिव पूर्व सैनिक कल्याण विभाग आदरणीय डॉक्टर नितेन चंद्रा जी आपसे। आपकी तालियों के साथ हम स्वागत करते हैं डॉक्टर नितेन चंद्रा जी का।
Dr. Jitendra Singh, Honorable Minister of State of the Ministry of Science and Technology, Minister of State for Prime Minister's Office, Ministry of Personnel, PG and Pensions, Department of Atomic Energy and Department of Space, Government of India, Shri V. Srinivas, Secretary, Department of Pension and Pensioners Welfare, Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Shri Vikramjit Banerjee, Learned ASG, Dr. Chabilendra Rawal, Honorable Member, CAT Delhi, and Shri Dhrubajyoti Sengupta, Joint Secretary Pension. Very learned, our Attorney General, Shri Venkat Ramani, who has joined us from Hawaii. Namaskar, sir.
Namaskar.
And very learned and distinguished participants who have gathered on this very great and important subject of pension litigation, which affects more than 60 to 65 lakh people. I'm adding civilian pensioners also, which the Mr. V. Srinivas is dealing with. The pension ecosystem in defense is very distinct from the pension system in the civilian services. We have a component which is called disability pension, which does not play such a big role in the civilian pension. That component is also there, but it does not play such a significant role. But in defense pension, that plays a very, very important role, very major role. And the reason is that the personnel who are, the defense personnel who are enrolled in the three services, Army, Air Force, and Navy, they do not have a fixed age of superannuation the way civilian employees have. The civilian employees would retire typically at 60 years of age, and the defense personnel have variable dates of superannuation depending on their ranks. But there is one more additional element. Their continuation in service depends on their physical fitness, and their physical fitness is like the APAR of the civilian employees. So they have to be physically fit, and for which a medical evaluation is constantly being done for them. So if they are not physically fit, they are given chance to improve themselves. If they can't improve, if there is something drastically wrong, then they are discharged from the service. So that could be at a very young age. What we find is that the severance from service in the defense personnel on an average happens around, let's say, 40, 45 years of age because of this issue of physical fitness. And the reason is very genuine, because the forces have to be kept young and energetic. You can't have people who are not fit working in the forces. Now this gives rise to a very interesting phenomenon. Every year 60,000 people are discharged or superannuated from the services. Their average age would be around 40, 45 years. So in addition to the task of giving them the right pension, the right is in quotes because their pension includes the disability component also. In addition to giving them the right pension, the responsibility is also on the government to take care of them and their families for the rest of their lives through a variety of welfare programs, which includes giving them the right skills, the knowledge for new jobs, new employment, whether in the private sector or in the government or maybe self-employment. Second, we have an array of health services just like you have in CGHS for the civilian employees. We have what is called ex-servicemen contributory health scheme, which is called ECHS, which is at par with CGHS, but it is dedicated exclusively to the ex-servicemen. So this is a very big task and a big budget of the Government of India, which goes into health care services, almost roughly 10,000 crores a year for the defense retired personnel. And this is exclusively for the retired person, this health services, not for the working, as you have in CGHS, both for retired and working employees. Then we have a host of welfare schemes, which includes giving their children scholarship, giving them loans for building houses or purchasing vehicles, and so on and so forth. So we have a host of around 13 schemes for these ex-servicemen. And most interesting, sir, what you would like to know is that we not only deal with ex-servicemen who are of Indian origin or who are Indian citizens, we also deal with ex-servicemen who are Nepali citizens. So there are almost 1.5 lakh Nepali citizens who have had association with the armed forces, because the armed forces prefer to have enrollment of these Nepali citizens, Gorkha particularly, in the armed forces. Therefore, we have almost 1.5 lakh employees, retirees in the Nepalese population, and we provide them pension on a regular basis, and that is done through the channels of the embassy, and we have a system of what is called SPARSH. SPARSH stands for System of Pension Administration in the Raksha Mantralaya. So this is an automated system by which we have almost 32 lakh pensioners on the system, and the entire process of pension administration, right from the submission of claim by the pensioner to the issue of the PPO by the pension disbursing and the paying agency, the entire process is fully automated and the whole thing is fully centralized. So every pensioner, irrespective of his location, would access the SPARSH portal, go to the system and log in, create a login ID for himself, and place his claims and the entire process then gets verified, scrutinized, examined by the different auditors, accounts officers, and their senior officers who are in charge of pension administration. So this is a very big achievement, for which the credit actually goes to the Defense Department, Department of Defense, not my department. Because we have in the ministry a unique system by which part of the work of pension administration is done by our department, which is a policy-making department, and then part of it is done by the Department of Defense, which is actually having the Defense Accounts Department, which manages the pension disbursement system through the SPARSH portal. And then we have Department of Military Affairs, whose personnel actually receive the claims of pension from the pensioners and process it and through the SPARSH portal and send it to the Defense Accounts Department for final creation of the PPOs. So 3 departments are very closely involved in the entire process of delivery of pensions to almost 32 lakh pensioners. And because there is a discretionary element of disability pension, disputes often arise as to the quantum of disability pension. Disputes don't arise on the pension because that is a very straightforward calculation as to what the pension amount is. But here there is a discretionary amount of disability pension which is to be assessed by a competent body through the pension policy, under the pension policy. So the policy would say that there should be, before a defense personnel retires, he should go through a medical board examination. The medical board would assess his physical fitness. He may be fully fit, no disability, disability 0, or he may be having some disability. So if he has, let's say, 100% disability, then 30% of his emoluments is added as a disability pension. If he has 20% or less than 20% disability, nothing gets added to his disability pension. But it is somewhere in the range, let's say 20% to 100%, then that fraction, 75%, 50%, is of the emoluments is added to his total pension, which becomes his disability pension. And the entire package of pension plus disability pension is also, sir, income tax free. It is exempted from income tax. So this is a very big benefit which goes to the defense personnel. Since the disability pension component is discretionary, the pensioner often challenges the computation of that discretionary amount. If they are not happy with that, then they challenge that. So almost 1/3 of the such pensioners would challenge that. And that is what is resulting in a lot of litigation in the Defense Ministry, because the discretionary component is being adjudged by, let's say, or being felt by certain pensioners as not adequate. So there, the matter goes to the Armed Forces Tribunal. From there it goes to the High Court, and then it goes to the Supreme Court. Their matters get decided. We have a lot of landmark judgments. We have the able guidance of our Attorney General, who very ably defends our cases in the Supreme Court, obviously, and if need be, he also appears on our behalf in the High Courts also. So we are very thankful to him. We are very grateful to him. We are working hard. Our goal is to reduce litigation, and therefore, and we are very thankful that we have got now the pension litigation, the directives on the litigation management, effective and efficient conduct of litigation. So it is a very timely thing which has happened. On the 4th of April, this directive was issued, and we find that directive very useful in the management of our litigation. It has helped us build our capacity. The litigation policy, the directives, one of the component of the directive is that the departments must look at their litigation management system, and if there are deficiencies in capacity, they should build their capacity. So we allowed the armed forces to have more number of legal professionals. So we got more than 50 legal professionals, new additional legal professionals sanctioned for the armed forces. And they now, I think, are able to deal with the litigation that is arising. And we emphasize that only those cases we should litigate where there is a friction with the policy. If our policy says that a disability has arisen to the person, let's say he is having hypertension or he is having diabetes, and he is not, that disability is not due to the service conditions, not aggravated by the service condition, not attributed to the service condition, then he should not be given disability pension. But where it is so, he is provided disability pension. So we are very careful in making this distinction. And when a claim comes and where we feel that yes, he should be granted disability pension as per the policy because the disability is attributable and aggravated due to the service conditions, the jobs that he has performed, then we allow the disability pension. That is helping us in reducing the burden of litigation. But we need to create more awareness among the pensioners, also among the members of the Armed Forces Tribunal, and we also solicit the support of the Additional Solicitor Generals, the Attorney General, and the other central government standing councils to understand the policy in a way that it gets implemented in a just and fair manner, ensuring justice to all, and everybody gets the share that he deserves to get. I am very thankful to the Department of Pensions for giving us the opportunity to share our thoughts and understand how we can improve this complex system so that the lakhs of litigants, pensioners who are toiling in the, let's say, tribunals and the courts for getting justice, their burden is minimized. Thank you very much.
Thank you, Sachiv Mahoday. बड़े गर्व की बात है कि आज हमारे बीच सचिव विधि आदरणीय डॉक्टर अंजू राठी राणा जी उपस्थित हैं। सरकारी कानूनी प्रशासन और नीतिगत निर्माण में व्यापक अनुभव रखने वाली सचिव महोदया देश की पहली महिला विधि सचिव हैं। आपने कानून के क्षेत्र में दशकों तक सेवा दी है। मैम, आपसे अनुरोध है, कृपया हमें संबोधित करें।
Respected Honorable Minister of State for Personal, Public Grievances and Pensions, Dr. Jitendra Singh, Lord Attorney General of India, Shri R. Venkatramani ji, Shri V. Srinivas, Secretary Department of Pensions and Pensioners Welfare, Dr. Jitendra, Secretary Ex-Servicemen's Welfare, Dr. Raul, Honorable Member CAT, Delhi, Shri Vikramjit Banerjee, Learned ASG, Shri Dhruv Jyoti Sen Gupta, JS Pensions. Distinguished officers, legal professionals, colleagues and participants, a very good afternoon to all of you. It is my privilege to address this national workshop on pension litigation, which brings together the Government of India's legal and administrative machinery to deliberate on an issue that touches the core of public service. Pension, as we all know, is far more than a mere statutory entitlement. It is the state's commitment to its retired personnel who have served it faithfully. In recognition of decades of public service, it sustains livelihood, ensures dignity, and often constitutes the sole financial support for retired government servants and their families. Yet, pension entitlements today rank amongst the most litigated aspects of government administration. The Department of Legal Affairs, Ministry of Law and Justice, and the Department of Pension and Pensioners Welfare have time and again encountered the legal and human cost of this unfortunate trend. At present, a very huge number of pension-related cases are pending across the Supreme Court, High Courts, and Central Administrative Tribunals. These matters range from arrears arising out of revised pension calculations to interpretational disputes under the CCS pension rules and eligibility questions regarding family pension. But the pattern is consistent. What should have been resolved at the administrative stage often lands up in court. These are not just legal technicalities. Each case represents a delay in entitlement, prolonged anxiety for a pensioner and their dependent family members, and an erosion of public trust in the system. Some of the recent judgments, like those concerning parity in pension for pre-2006 retirees or pension forfeiture for absorbed PSU employees, carry substantial financial and policy implications. Department of Legal Affairs has closely studied the recurring issues. We have found that adverse outcomes are often rooted in inconsistent legal positions, delayed communication with counsel, and fragmented interministerial coordination. Too often, legal scrutiny happens after the damage is done. Legal advice is sought after the matter reaches the court. Briefs are dispatched at the last minute, and ministries act reactively rather than proactively. We saw this recently in the Finance Act 2025, where legislative validation had to be introduced to address and uphold certain classifications in pension matters. It reflected how litigation can complex legislative interventions and emphasized on the need for early legal vetting of policies and timely preparation of well-founded legal defenses. So the lesson here is clear. Preventive legal strategy must replace curative litigation, and this is where nodal officers and legal cells play a very important role, not as crisis responders, but as early sentinels at the very stage when a policy is being drafted, not challenged. An office memorandum issued by the Department of Legal Affairs on 4th April 2025 with regard to directives on effective management on litigation has issued guidelines such as early consultation with nodal departments such as Department of Pensioners and Pensioners Welfare, and strict adherence to timelines to avoid contempt of court proceedings. Pension litigation must not be viewed as a routine matter. It must be handled with the seriousness it demands, with clarity, with compassion, and above all, with competence. I am heartened to note the progress we are making on the litigation management front. The integration of LIMS, Legal Information Management and Briefing System, with court websites to auto-fetch case data is a significant step forward. Even more promising is the proposed multi-ministry module, which will enable real-time coordination between the Department of Legal Affairs and the Department of Pension and Pensioners Welfare, standing councils and the concerned ministries. But systems alone can't solve problems. People do. We need active case monitoring, timely legal advice, and administrative ownership at every stage. As officers of government and custodians of the law, our collective role is to ensure pension entitlements are implemented fairly and promptly, to build legally sound litigation-resistant policy framework, and defend the government's position effectively when litigation is inevitable. This workshop is a call to action to coordinate better, to litigate smarter, and above all, to serve our retired employees with the dignity they have earned. Let us all remember, every avoidable case is a cost on the government exchequer, on court time, and on the patience of a retired employee. And every lost case is a reminder that legal preparedness must begin in the ministry, not in the courtroom. I commend it is a part of how the state writes its gratitude. Thank you so much. Jai Hind, Jai Bharat.
सार्वजनिक क्षेत्र के उपक्रमों का प्रतिनिधित्व किया। वहीं दूसरी ओर अंतर्राष्ट्रीय स्तर पर 2024 में यूएन ह्यूमन राइट्स कमेटी के समक्ष और अक्टूबर 2024 में G20 प्रोसिक्यूटर जनरल्स कॉन्फ्रेंस में भारत का प्रतिनिधित्व किया। सर, एक बार पुनः आपका बहुत बहुत स्वागत है। आपसे अनुरोध है, कृपया हम सबको संबोधित करें।
Good evening. I hope I'm audible from a long distance.
Yes, sir. Yes, sir.
Very well. Very well. My regards to the Honorable Minister, and who heads several departments, and I am in fact interested in noticing that he heads Department of Atomic Energy and Space, probably two departments which do not have pension litigations in the other departments of the Government of India, and I should be too happy about it. And speaking from a faraway distance from Hawaii, I wish to be very brief. When I entered the office of the Attorney General, one of the most pressing concerns was how do we generally deal with litigation, not merely pension litigation. I looked briefly at litigation management policies in various states, and working with initially Dr. Jitendra and later with other secretaries, we thought what's important is to have a national litigation management policy. By now, working over almost a year and a half or more, we have a national litigation management policy which looks at litigation in various dimensions. But pension litigation occupies a very different space altogether, in the sense that unlike any other entitlements, pension has certain other concerns and features which are different from a right to promotion, a right to appointment, and so on and so forth. So we are more concerned with ensuring that, if possible, by 2028, another 2.5 years or so, we will have a zero pension litigation target. In the sense that if we are able to ensure that within departments and at the administrative level, We can have what Dr. Anjula Tirana talked about, a curative, instead of curative, and then we have an anticipatory mechanism by which all possible litigations, potential litigations can be handled. But when Dr. Chandra also talked about the armed forces pension issue. They are a very complex situation. Again, when I took over this position almost 2 years ago, we found several thousand armed forces pension litigations are pending. A few steps have been taken, but I think I'm not very confident that we have done the best for armed forces pensioners. We need to still go a long distance before we can probably pat ourselves on the back and say that we have a system where pension litigation probably doesn't occur at all. If that's going to be our target, I think it's not merely a question of redoing our rules. I know as any rule can be interpreted in more than one way, as long as courts say that pension is not merely a right but a bounty. But it's not merely a question of redoing our rules. Whatever rules we may have, people may still have some grievance, courts may still have interpretative engagements and so on and so forth. But the point, however, it is, in a recent national conference on mediation, we were talking about how to look at mediation as the most effective tools of minimizing litigation. After national conference is over, I've been receiving lots of requests and people reaching out from different parts of a country, both public and private, that if an element of conciliatory measures can be brought into pension management, I think that will be a great step forward. And the Supreme Court beginning to talk about mediation as a major way of dealing with litigation. Look at what our country is facing compared to several other countries. There is no other country in the world where we have a system like ours with the civil service pension, where we have this kind of a huge litigation. The Supreme Court and the High Courts are saddled with huge amounts of litigation and pension. Therefore, I think it's important for us to do what is the best way of going about it is to find out at the administrative level amelioratory measures and bring over certain accountability in what we're doing in pension. So particularly in the context of armed forces, I found there are a lot of delays. I don't know why delays should ever occur at all in pension management. And very often in Supreme Court, because of delays, matters get dismissed. And the delays are not merely a few days or a few months. They run into more than a couple of years. And I think it's impossible that somebody should say, I will sit over a matter for more than a year and a half. Since the minister is here, I would probably appeal to him to say that the sense of accountability in handling matters, given the huge technology leap which we have with us, and the technology management we have with us, I think it's going to be very easy and probably an attainable goal to say that delay will probably be a matter of the past in the next months to come. If only by December we're able to say that in pension litigation, delay will be a matter and history, then I think we would have done good for our country. Therefore, we look at each and every aspect that contributes to litigation and say how we can manage them. I don't think we can probably have all fit a basket for every aspect of pension litigation. We need to look at each one of them and say how each one of them can be handled, eliminated, avoided, and if possible. So I'll probably appeal to the minister once again to say that we've been talking about nodal officers, connecting law ministry with the other ministries, etc. But I wish it works a little more effectively. And if in the Department of Pensions, we have a nodal office directly connects with the Attorney General's office, the ASCs, and we have a standing conference of all the law officers together, so that the drop of a small button, of a touch of a button, I know what's happening in the rest of the country, in what kind of litigation, and how do I connect to each one of the law officers or the standing counsel across the country. We do not have connections at all. First, we need a connectivity. Therefore, a standing platform of from the Attorney General office downwards, I think is going to be very important for us. Once we have a standing platform which is get digitally connected, many more efficient ways of handling litigation can also happen. So we need to have a wide range of programs from avoiding litigation, managing litigation, and closing litigation. So if you look at all the three of them together, and I think probably if we would have, as I said, by 2028, we would have said India has a zero pension litigation. And if that's going to be achieved, I mean, we all talk about pursuit of happiness. A pursuit of happiness means good for retirees. I think we should all be able to assist the pursuit of happiness. And how are you going to do that? It's not a very difficult job. And where there is a will, there is a way, as people talk about it. In this brief time, I thought, speaking from a long distance, these are a few thoughts I wanted to share with you. But back in Delhi, I'm sure we will have a quick roundtable conference on a meeting on how do we carry forward these very brief ideas and sitting together. And then, as I said before, the session commencing in December, we're going to place before the Parliament what India is going to proudly say, what it can do for its pensioners. With that, I think, thank you for giving me the opportunity of talking to you. The long distance is about 10 o'clock at night here, but still I thought it's my duty as Attorney General to reach out to you and share my few thoughts and reflection. I'm sure that with the contribution of each and every one of the law officers and the Standing Council, we'll be able to say, as I said, I would like to probably before my term comes to an end, probably able to say that within the 3 years, one great achievement that the Office of Attorney has been able to do is to say that litigation has dropped to a zero level, and particularly in pension. What a great day of happiness can that be. Thank you so much.
धन्यवाद सर। इस महत्वपूर्ण ज्ञानवर्धन संबोधन के लिए बहुत बहुत आभार। साथ ही हम आपका आभार व्यक्त करते हैं वीसी से हमारे साथ जुड़ने के लिए। बहुत बहुत धन्यवाद सर। अब हम माननीय मंत्री महोदय जी से विनम्र अनुनय करते हैं, कृपया विभाग द्वारा तैयार की गई बुकलेट कंपेंडियम ऑफ केस स्टडीज ऑन पेंशन लिटिगेशन का विमोचन करें अपने कर कमलों द्वारा। आपकी तालियों के साथ कंपेंडियम ऑफ केस स्टडीज ऑन पेंशन लिटिगेशन का विमोचन। माननीय कृपया पेंशन लिटिगेशन पर तैयार किए गए फ्लायर का भी विमोचन करें। विभाग द्वारा पिछले वर्ष कुटुंब पेंशन भोगियों की शिकायतों के निवारण के लिए 1 से 31 जुलाई तक 1 माह का विशेष अभियान संचालित किया गया। माननीय इसकी बुकलेट तैयार की गई है, कृपया इसका भी विमोचन करें अपने कर कमलों से। आप सबकी तालियों के साथ विशेष अभियान की बुकलेट का विमोचन। और इस वर्ष भी 1 से 31 जुलाई तक विशेष अभियान 2.0 संचालित किया जाएगा, जिसके दिशा निर्देश माननीय मंत्री महोदय जी ने 18 जून को नेशनल मीडिया सेंटर से एक प्रेस कॉन्फ्रेंस द्वारा जारी किए थे। माननीय, अब आपसे अनुनय है कुटुंब पेंशन भोगियों और अति वरिष्ठ पेंशन भोगियों की शिकायतों के निवारण के लिए 1 माह तक संचालित विशेष अभियान 2.0 का शुभारंभ करें अपने कर कमलों से रिमोट का बटन दबाकर। तो विशेष धन्यवाद माननीय। मंचासीन सभी गणमान्यों का भी आभार। ये हमारा परम सौभाग्य है कि हमें माननीय राज्य मंत्री डॉक्टर जितेंद्र सिंह जी जैसे अत्यंत गरिमामय व्यक्तित्व का सानिध्य आज प्राप्त हुआ है। पेंशन संबंधी नीति निर्माण, नियंत्रण तथा प्रशासन में पथ प्रदर्शक के रूप में सबसे महत्वपूर्ण भूमिका का निर्वहन करने वाले माननीय मंत्री महोदय जी से हमारा विनम्र अनुनय है, अपने विचारों को प्रकट कर हमारा मनोबल बढ़ाएं, हमारा मार्गदर्शन करें। आपकी तालियों के साथ माननीय राज्य मंत्री जी।
Secretary, Administrative Reforms, Pensions, Grievances, Government of India, Shri V. Srinivas ji, Secretary Law, Dr. Anju Rathi Rana, Secretary Ex-Servicemen Welfare, Dr. Nitin Chandra, and joining us from a distance, as he himself mentioned, close to midnight, the Attorney General, Shri R. Venkataramani, Dr. Rao, Member CAT, our colleague in the department, Mr. Singh Gupta, ASG Amit Banerjee, senior officers from the different ministries, also members of the legal fraternity. At the outset, I have to congratulate Mr. Srinivas, Dr. Rathi Rana for taking this initiative. And as has been said earlier, it's of course the first of its kind, a new experiment, and I'm sure is going to come with the outcomes that have been envisaged. And it is also a true reflection of what Prime Minister Narendra Modi keeps reiterating, the whole of government approach. When all these gentlemen and gentle ladies come together, what wonders can be done, I think, is what is thought to be presented over here today. Now, the question is, why this workshop, first of all? I think, A, the number of pensioners has increased, and it is increasing with each passing day. Also because the average lifespan of an Indian has increased. At the time of independence, it was just about 50, 55 years. Now it's close to 80, progressively going up. Many of our friends at that point in time did not have even the privilege to be hosted a farewell party because they would not live long enough to see the last day of retirement. Now it's the other way around. Sometimes they're living as long as they have been in the service after superannuation. And that is also the reason that for several years after independence, it was assumed that the number of pensioners was not very large enough, often manageable, and the subject never came up for discussion. Today, for the last few years, the other way around. The number of pensioners is more than the number of working employees. If you take only the central government pension, it's more than 60 lakh now, which is somewhat more than the working central government employees. And the burden of the state exchequer is more on account of the pensions paid than on account of the salaries paid. So this is an issue with a multifactorial genesis. And upon that, the retirement age around 60 is now considered a second inning. It's not even considered an elder age now. When they retire at the age of 60, they are at the peak of their not only energy, also expertise and experience. And also the challenge is therefore how to best to make use of their experience and abilities at that point of time, instead of just leaving them idle so that they come back with an RTI. And therefore, because of the number also, and because of also the ability to deal with the issues, because earlier on, maybe by the age of 60, you were, too exhausted, too tired even to take care of your daily course. But here, the number of issues have also increased, and the scale of issues has also increased. And the energy to pursue these issues also very much intact. And if you take from the point of view of what Prime Minister Modi keeps saying in the context of Viksit Bharat, that we need to have the energy of each and every citizen of India to be channelized in the making of that new India, ideally that energy should be put to use for that constructive work. So the whole process, the whole thinking, the whole ideology should be directed how best to prevent them from squandering their energies in whatever way, including litigation. And therefore, it becomes the responsibility of the Department of Pensions and Pensions Welfare, because earlier on, though the department spelled DOPWW, Department of Pension, Pensions Welfare, but it was mostly confined to pensions. Now the pensioners' welfare component has taken over the pensions, because the pension is taking care of itself. You have electronic PPOs, you have DG logs. So pension takes care of itself, the welfare part is still with you. And if that also goes, you'll be out of job. But that's now a huge, huge responsibility. And therefore, all the more to realize that there needs to be a considerable degree of sensitivity on the part of all the stakeholders. And we must also not underestimate or undermine the one who is going for a litigation, because often in this country, litigation is usually the last option for most of the citizens, unless it's a professional litigant, which we are not, I hope, discussing today. And therefore, it becomes a responsibility and also obligation on the part of the department to take care of this aspect. And that's why I think this entire exercise has been conceived. I was talking to Mr. Srinivas, there are close to 300 such litigations right now also. But they have been responsive. Like, for example, there was this judgment regarding 6th Pay Commission. They immediately carried out the orders, issued the notification. Similarly, very recently, the Unified Pension Scheme. And therefore, in spite of all that, if there is something more to do, we have now engaged in this workshop for the nodal officers. And also, as Mr. Srinivas was saying, working on that portal and how best to improve it. The Attorney General was making a very important observation, how best we could remain real-time connected. I'm glad to hear this from him, because till a few years ago, maybe before he took over, the common complaint was that they did not get an appointment in the Attorney General office. So if the Attorney General is himself offering, I think this is a good omen for you. You could even have a dashboard directly connected. And second, his wish that litigation to come down to zero, which he said, which is talked in the context of the happiness index, which is being discussed all over. So certainly it will bring happiness, but I don't know whether to all sitting in this room. Because I was told by Mr. Srinivas that there's a huge lot of practicing lawyers over here. But then I have an optimistic note for them also. And I want to assure these friends, like we have the experience of CAT. When CAT was established, the thought was that A, it would bring ease for the serving employees instead of going and knocking at the doors of the court, and B, it will reduce the burden of the high courts. But unfortunately, you could just, but unfortunately, none of the two happened. Each one who goes to the CAT also later goes to the High Court. Either way, if government loses, it goes to the court. if the litigant officer loses, he also goes to the court. So I think my friends sitting in these 5 esteemed rows can be rest assured. In spite of Attorney General's wishful thinking, I'm not sure whether we'll go close to zero. And when a litigant loses, even in CAT, and he goes around asking some acquaintances in the legal fraternity, invariably he'll told that he will win. So I think there's a very good ecosystem in place. How best to break it is a challenge. Ideally, it should be, as Attorney General is saying. But being a clinician and a researcher, I'm also trying to familiarize you with the tangles over there. And I hope you are, and as far as Mr. Srinivas and Dr. Rathi is concerned, if you train the nodal officers so well that they get all the issues resolved very fast, even through the court, I wish more and more number of pensioners do not find it convenient to take that course instead of taking another course, because they would then find it easier to get this resolved over here. So, but nevertheless, that is not to say that, not to discourage this initiative, rather this is some of the teething problems we might face in the beginning. But all said and done, this is a healthy initiative. And I think at the end of the day, and as the Attorney General was saying, we could have data connected. I think to add to that, we could even have an AI-driven repository so that you could not waste on the manpower. So automatically it will get generated. But the other part of it, as far as the being considerate about the individual cases and being sensitive about it, will have to be taken care of by the human intelligence, HI, not AI. So that hybrid model would also have to be experimented, at least to begin with. And I think the purpose would be served if all of us have a common intention, a sincere and honest intention that, look here, we are doing all this ultimately with one single objective, that we have to ensure that every inch of the energy of our elder citizens is put in the positive channel for the making of New India, rather than it's squandered either way, whether through litigation, whether through RTI, whatever. Because I think I would conclude by saying that those who retire may retire from the government service, but they have not retired from the service to the nation. And if that is the thought that we could inculcate in them, and we could make a common goal, I think that is the only way we could actually succeed optimally in this endeavor. Nevertheless, I would compliment Mr. Srinivas, Dr. Rathi Rana, and I'm sure it meets a better fate than CAT has. And I'm saying this in the presence of the member of CAT. Once in when I said, do we need to continue with this? But nevertheless, I think we have learned from that experience, and we would not let that happen. We would take it to the next level. Thank you very much.
इस प्रेरक संबोधन के लिए माननीय आपका बहुत बहुत आभार। और अब हम सचिव पेंशन एवं पेंशनभोगी कल्याण विभाग से अनुरोध करते हैं माननीय राज्य मंत्री महोदय जी को स्मृति चिन्ह भेंट करें। आपकी तालियों के साथ संयुक्त सचिव पेंशन जी से निवेदन है, कृपया सचिव पेंशन जी को सचिव पेंशन जी का स्मृति चिन्ह से संयुक्त सचिव महोदय से धन्यवाद सर। सर आपसे पुनः अनुरोध है सचिव पूर्व सैनिक कल्याण विभाग आदरणीय डॉक्टर नितिन चंद्रा जी को भी स्मृति चिन्ह भेंट करें। पुनः अनुरोध है विधि सचिव आदरणीय डॉक्टर अंजू राठी राणा जी को स्मृति चिन्ह भेंट करें। लर्नर्ड एडिशनल सॉलिसिटर जनरल आदरणीय श्री विक्रमजीत बनर्जी सर को स्मृति चिन्ह भेंट करें। सर पुनः अनुरोध है ऑनरेबल मेंबर कैट प्रिंसिपल बेंच दिल्ली आदरणीय डॉक्टर छबिलेंद्र राहुल जी को स्मृति चिन्ह भेंट करें। धन्यवाद सर। और अब वोट ऑफ थैंक्स के लिए मैं निदेशक श्री राकेश कुमार जी को मंच पर आमंत्रित करती हूँ।
Good afternoon, everyone. It is my honor and privilege to deliver the vote of thanks at the conclusion of this important and timely national workshop on pension litigation. At the outset, I extend my deepest gratitude to Dr. Jitendra Singh ji, Honorable Minister of State, Personal, Public Grievances and Pension, for gracing us with his presence and delivering the inaugural address. Sir, your visionary guidance and unwavering commitment to pensioner welfare continues to inspire and shape our work at the Department of Pension and Pensioner Welfare. We also deeply thankful to Sri R. Venkatramani, Learned Attorney General for India, for joining us virtually from abroad. Despite his present pressing engagement, he made time to share his profound legal insights, which greatly enriched today's deliberations. Our sincere thanks to Sri V. Srinivas, Secretary DOPPW, who has been the guiding force behind this initiative. Sir, your vision and persistent effort have made this workshop possible and purposeful, and we thank you for your dynamic leadership. We also thankful to Dr. Nitin Chandra ji, Secretary, Department of Ex-Servicemen Welfare, for sparing his valuable time to attend his workshop. His insights were deeply informative and added meaningful context to the broader discourse of pension litigation. We are privileged to have had the presence of Dr. Anju Rathi Rana, Secretary Law, whose legal expertise and valuable inputs had greatly enriched the discussions. Our sincere thanks to Sri Vikramjit Banerjee, Learned Additional Solicitor General of India, for serving as a distinguished speaker today. His deep understanding of pension jurisprudence and litigation has been highly informative and thought-provoking. We also thank Dr. Shavilendra Raul, Honorable Member A. CAT, Delhi, for being a speaker at today's workshop. His practical insights from the perspective of the tribunal has been particularly helpful for all stakeholders present. A very special thank you to Sri Dhruv Jyoti Singh Gupta, Joint Secretary Pension, for his tireless efforts in conceptualizing, coordinating and delivering the workshop with such precision and purpose. A very special acknowledgement to Sri T.P. Singh, Senior Government Legal Counsel, who had only attended this workshop despite his demanding schedule, but also graciously accepted our invitation to be a speaker. His vast experience and practical insights added significant value to the workshop discussions. We extend our sincere thanks to Praise, who is covering this workshop. We extend our sincere thanks to all senior government legal counsels who joined us today despite their busy professional commitments. Their active participation and legal wisdom played a crucial role in the success of this workshop. We are grateful to all the officials from various ministries and departments whose presence and participation demonstrate the spirit of interdepartmental coordination so necessary for resolving pension issues in a comprehensive and citizen-centric manner. Last but certainly not the least, I extend my warmest appreciation to all my colleagues and officers of the Department of Pension and Pension Welfare. Your dedication and teamwork have been instrumental in this smooth, successful conduct of this workshop. To all our participants and guests, thank you for your active involvement, meaningful discussion, and for joining us in our collective mission to improve the pension landscape and reduce litigation through clarity, compassion, and collaboration. Thank you all once again. Jai Hind.
आप सभी लंच के लिए सादर आमंत्रित हैं। नमस्कार, जय हिंद।
फोटो के लिए आने बोल रहा था।